guys ready? Yep. I'd like to call to order the Board of Appeals meeting for this evening. I don't think it makes much point to have another moment of silence and salute to the flag. We just did one. So we're here for petition 1, which is petition filed on an appeal of the decision of the Hopkinton Planning Board filed by Remedy Energy LLC, appealing 2 of the conditions set by the Planning Board, granting the development plan for photovoltaic solar energy system located at 15 Frontier Road and identified as Assessor's Plat 7, Lot 62, 62A, and 63, filed by Remedy Energy LLC in accordance with Rhode Island General Law 452367 as amended. I know, I go fast.
She's good.
You okay?
I'm good.
Okay, tell me to slow down, because I get rocking and rolling when I'm reading. Okay, so do we have both parties here?
Yes.
Yes. Would you care to restate your position at all, or have any more discussion? We pretty much went through all of the testimony, and we were at really deliberation amongst the board, so I didn't know if there was any other discussion.
We have nothing further.
Nothing further? Oh, okay.
Nothing further from the applicant.
Can I just take your name?
Absolutely. Nick Nivo, Senior Legal Counsel for Remedy Energy LLC. I'm here this evening with Karen Browning. And the applicant has nothing further to add to the record.
Okay. How about anybody from the public? Is there anybody else that would like to speak? No? Okay. Entertain a motion to close the hearing.
So moved. Second.
Second, discussion? All in favor?
Aye.
Okay, so now we're at the point we're going to deliberate and we'll gather our findings of fact. Would you guys prefer we go right into findings of fact and then have some discussion based on those? That makes sense? And it sets up a good framework?
In a couple months.
Yeah, it's fun. Well, it'll be a good refresher. So just as we go into that, and correct me if I'm wrong, this is going off of my memory, that we have 2 issues to address, and it's whether the planning board made an error of law in imposing condition number 5, which is vegetative buffering along Maxon Hill Road, and whether the planning board made an error of law imposing condition number 20.
I'm sorry, whether the planning board made what?
Whether the planning board made an error of law in imposing condition number 26, which is hours of operation. So the question for both is whether under the general laws, the planning regs and the zoning ordinance, including the DPR ordinance in section 13.5 of the general code, that the planning board has the authority to impose these conditions. So that's a little overview of where I feel we're at. And again, we're in an unusual position. We're not supposed to be changing the judgment of the planning board for our own. We're just supposed to be making sure that they did things appropriately. We don't serve as this board a lot. It's a rare occasion that it happens. So if we can keep that in mind when we're deliberating, we might have opinions as to how we would have voted on things, but that's not really relevant. We just want to know if they applied the correct ordinances and laws and in making the determination. Again, correct me if I'm wrong in any of those statements.
Essentially, you can't substitute your own judgment for that of the planning board. It's just whether the decision rested upon legally competent evidence or...
I'm sorry, could you, I can't really see you.
Hi.
Yeah, hi, if you could just speak up just a little bit. That would be
The
helpful.
standard is essentially that you can't second guess the planning board. You can't substitute your judgment for it. You just have to evaluate their position based upon the evidence presented, and essentially at the end of the day, in this case, determine whether or not they have the authority to impose the conditions that they imposed.
Okay. Do you have any findings of fact? Not to put you on the spot. I can entertain a bunch, but I'm not...
At the end of the day, it's a very narrow scope. It's the 2 you just stated, the hours of operation, which is for construction of the facility, and B, the buffer, which relates to the residential zone.
So if you want to see this how I like to talk so much, I'll entertain a bunch of these as findings of fact. If you'd like to pull any out,
Yeah.
stop me.
Yeah.
Let me do that. So I'd entertain a few of these things as findings of fact. First is that the subject property is located at 15 Frontier Road, Assessors Plat 7, Lot 62, 62A, and 63. Also that the applicant, Revity Energy LLC, filed for development plan review before the planning board seeking to construct an 11.3 megawatt direct current photovoltaic solar system, or PSES, on the subject property. The subject property is zoned industrial. The PSES is a permitted use in the industrial zone. No zone change was required in connection with this project. The area to the east and southeast of the subject property on Maxon Hill Road is zoned RFR 80, a residential zone. Revity's DPR application came before the planning board for pre-app application on November 6, 2019, and for DPR on March 4th, 2020, June 3rd, 2020, July 1st, 2020, July 15th, 2020, August 5th, 2020, September 2nd, 2020, and October 7th, 2020. On October 7th, 2020, after the planning board approved the applicant's development plan, subject to 26 conditions. The applicant is challenging 2 of those conditions on the basis of the planning board lacked the authority to impose them. The 2 conditions that are challenged are condition number 5, the existing vegetation within the 100 feet setback area along Maxon Hill Road will remain in place and be supplemented with additional planting of evergreen trees of a minimum of 6 feet of height at the time of planting, as set forth in the approved landscaping plan. And then condition number 26, which is all site work shall be performed Monday through Friday between the hours of 8 a.m. and 5 p.m. Eastern Standard Time. The zoning ordinance addressing dimensional regulation requires that where commercial or manufacturing property abuts a residential zone, district boundary, the side and rear yard setback area abutting said residential boundary shall also be maintained in a vegetative condition. This is in the Hopkinton zoning ordinance, section 6, footnote 2. There we go. The PSES ordinance in effect at the time of DPR and applicable to this project contains a section titled PSES Design Guidelines. The PSES ordinance, which was adopted on January 22nd, 2019, Section C. Section C of the PSES ordinance, subsection 1, titled Land Clearing and Environmental Cultural Impact, consists of 5 paragraphs. The first 2, I feel, are the pertinent ones in this. All PSES shall be constructed and operated in a manner that minimizes any adverse visual, safety, and environmental impacts. The design of the PSES shall use materials, colors, textures, screening, and landscaping that will blend the facility into the natural setting and existing environment. The proposed PSES shall be designed and will be constructed so that the ground leveling is limited to those areas needed for effective solar energy collection, and so that the natural ground contour is preserved to the greatest extent practical. In instances where a parcel is rezoned from residential to commercial and manufacturing use for the purpose of accommodating a PSES, existing soil conditions shall be maintained to the maximum extent practicable. No blasting will be conducted on the parcel in conjunction with any activity related to the construction of a PSES, including land preparation. The second paragraph states, in instances where a parcel is rezoned from RFR 80 to commercial or manufacturing use for the purposes of accommodating a PSES, clearing of any existing vegetation on the subject parcel for the purpose of constructing, operating, and maintaining a PSES shall be limited to a maximum of 40% of the total area of the parcel. Clearing of any existing vegetation within the front, rear, and side yard setback area is prohibited unless explicitly approved by the planning board. The PSES and equipment shall not have a significant adverse impact upon the soils, water resources, or quality or other natural resources of the surrounding area. So I still have a few more. I'd like if we can go back and revisit these, if if you'd wish. Right now, I'm just basically laying the framework of all the different ordinances and things that are out there, and then we can throw all of our opinions in there. So we go to section 15A of the zoning ordinance, requires DPR for all permitted uses except single-family and two-family homes along with their accessory uses. Section 15A requires DPR shall only be based on the specific and objective guidelines set forth in the DPR ordinance, section 13.5 of the town code. So if we go into the town code in, under section 13.5, item 75, it's the developmental plan review general criteria and standards. I don't want to get into the whole thing, it's rather lengthy, but there are several points within this that I do want to get on the record. One is the intro to that section, which is the following guidelines and standards include the design review guidelines contained in the town of Hopkinton and land development subdivision regulations are to be used by the planning board in judging applications for developmental plan review. The design standards set forth in this section shall serve as the minimum requirements for approval of the developmental plan application. In all instances, the burden of proof that all design standards have been met shall be on the applicant. The burden of proof shall include the production of evidence necessary to complete the application. So within that section under item C, it's titled Ecological Considerations. It says the development insofar as practical shall, one, result in minimal degradation of unique or irreplaceable land types, and in minimum adverse impact upon the critical areas such as streams, wetlands, areas of the aquifer recharge and discharge, steep slopes, highly erodible soils, areas with a high water table, mature stands of vegetation, and extraordinary wildlife nesting, feeding, or breeding grounds. Under the same section, subsection D, it says landscape. The landscape shall be preserved in its natural state insofar as practicable by minimizing tree removal. The rest of it doesn't seem quite as pertinent within that section. The record can be read. If we go to subsection G, it says soil erosion and stormwater control. Within item 2 of that subsection, it says the development shall be oriented to the site so that the grading and other site preparation is kept to an absolute minimum. Construction and other development plans calling for cutting and filling or stripping of vegetation may not be approved by the planning board if it is deemed that the proposed land use could be supported with less alteration of natural terrain or vegetation. I'm almost done. So then, item 6, also under the soil erosion and storm water control section, says development proposal shall strive for maximum retention of natural features and qualities of the site, and development shall seek to enlarge these features and qualities. If we go to section 13.5, number 76, this is planning board review and decision. Again, on the item A, it says reviewing the developmental plan, the planning board shall take into consideration the public health, safety, and general welfare, the comfort and convenience of the public in general, and the residents of the immediate neighborhood in particular, and shall set any appropriate conditions and safeguards in harmony with the general purpose and intent of all local regulations. And according to general criteria and standards set forth herein, some of the improvements that the planning board may approve as conditions include, but are not limited to, the following. There's several of those, they go on for about 9, but in this instance, it seems like the most important one is number 7, which is screening, fencing, walls, landscape areas, planting, strips, and other landscaping treatment that will enhance and buffer the premises and ensure compatibility with surrounding uses. Acceptable vegetation is outlined in the Town of Hopkinton Land Development Subdivision Regulation Design Review Guidelines. And then under item 9, it says mitigation of negative impacts as deemed necessary and appropriate in accordance with all federal, state, and local regulations. So, as I said, I would like you guys to entertain that as finding of fact. Anybody?
Are we trying to look at this, there's two items, so break these two items out and then kind of, I mean, you've kind of blended a lot of information there together.
Let's go into discussion. I mean, those are the pertinent findings. If you'd like to add any or omit some, I mean, that's an overview on it all. I'm not trying to add any opinion in this yet.
Well, specifically, and I'll go to the setback, if you want to start there or not, but to the residential zone, if you want to put buffer. It looks like the planning board went through great effort, and the applicant went through great detail. There's at least 15 or 20 pages of notes, August 5th, 2020, when they addressed the landscaping and the buffering, and that they specifically, Mr. Diorio, the chairman, pointed out that they did not want to see any of this from the road, and not just to be screened by a stockade fence, but layering of vegetation. So, again, I assume that they've satisfied the planning board with their plans, but at the end of the day, they're appealing this one item, which is a setback to the residential zone. And clearly, that's been the intent of our zoning ordinance out of the gate, is to protect the residential zones.
Correct. You're adding into the deliberation part?
Okay.
No, I mean, you can bring that up as another finding.
I just want to pull them apart, John, otherwise I think we're kind of going hairy-carry.
Yeah, I think you need to have the discussion prior to the finding.
So, all I'm stating is all of the different ordinances and regulations, right?
Yeah.
We can break out and touch back on those. Do you want to go back through, I mean, there's so many. All I'm stating is the ordinances.
Did the planning board err? That's the
Right,
question. period.
right. I want to go into discussion on it, but we got to get the findings on the table first, okay? We can add more findings, like,
How do you have findings before you have discussion?
you can do both at the same time.
Well,
You're welcome to, I'm trying to keep it clear for the record so that it travels easier. That's fine if you want to continue that way. Either way.
Again, I just think there's certainly, good, solid evidence in the minutes from the planning board meetings that they spent a lot of time, and that was, it sounds like one of the, one of the points of emphasis in terms of protecting visual aid, to the neighbors, period, and for the town, for the community, in planning. So, if that's item 1 or 2, however we're addressing this.
Well, the first several were just the time travel, the location of the property, I mean, just the basics. So then, and then, again, I readdressed what the conditions were that they were objecting to. So then if we get back deep into the weeds on this, let me get my brain wrapped back around it. So where I'm going with this is when I got into the section C of the PSES, in my own view, I want to be made clear, there's those 2 paragraphs that I read in. Those paragraphs, there's interchangeable language that talks about if there was a zone change through both paragraphs. If someone wanted to look at it in a favorable way for something they were doing, they would cherry pick certain items out of it. But in those 2 paragraphs, you can see that throughout both of them, zone changes are interchangeable with the whole discussion. Okay, so if we go back into that, that section, it's just to highlight the part that they would cherry pick out of there. It's in instances where a parcel is rezoned from residential to commercial and manufacturing use for the purpose of accommodating a PSES, existing soil conditions will be maintained to the maximum extent practicable. And then in the second paragraph, it says clearing of any existing vegetation within the front, rear, and side yard setback areas is prohibited unless explicitly approved by the planning board. That second paragraph also has language in there about a zone change from RFR 80 to commercial or manufacturing. Well, this is an industrial one, there was not a zone change, but this whole part of the ordinance uses language that interchanges and overlaps
It's
throughout.
consistent with both of them.
Yes, with both. So to pull those items out and say, well, this didn't require a zone change, they're using that incorrectly. Because if you read other parts of the sentence, it says the PSES and equipment shall not have a significant adverse impact on soils, water, no, that's the wrong sentence, I'm sorry. No blasting, this is in the end of the first paragraph. No blasting will be conducted on the parcel in conjunction with any activity related to the construction of a PSES, including all land operation. So if you read it with one thought process in mind, so you would say that if there was a zone change, they couldn't blast, but if there wasn't a zone change, they could blast. No, the clear intent is that there's no blasting to be done on a PSES in general, because they want to keep the contours, the landscape, and everything else to a minimum, which goes back into the developmental plan review guidelines and the town code, right? So that's what I'm trying to clear up in that with the findings of fact, is that the zone change is interchangeable with just the standard terminology too, that everything's kind of intertwined in there, and it's not, you can't cherry pick one over the other, it's all encompassing. So that's where I was heading with that.
So, I think the last thing that you pointed out there was the vegetation, any vegetation or changes in the buffer had to be approved by the planning board. I think that's, and if I remember correctly, an issue was they were requesting to selectively cut down some of the taller trees. At the time the planning board made the decision, they were not able to tell them which trees. It was based on models they had made in order to allow maximum capture of solar, of sunlight. So in my mind, the planning board was given information. They deemed it to be insufficient or whatever, however, they made a determination and did not approve the excessive clearing, and that sounds like it falls right under what you're saying.
Yeah, that's in the PSES under section C, but it also overlaps when you get into the town code under 13.5, item 75, and item 76. With throughout that document, it's talking about the minimum degradation to unique and irreplaceable land types, mature stands of vegetation. They shall preserve its natural resources in the natural state insofar as practicable by minimizing tree removal. When you go into the soil erosion, stormwater control plan, again, it talks about minimizing the impact, minimizing the stripping of vegetation and mature growth. So, I mean, it's all intertwined throughout all of these codes and regulations, that the intent of all of it is to minimize the impact on the community, on the visual aspects. It's not to maximize the overlay for a solar project, it's to work in harmony with it so that we get the best outcome, not to cripple them so that they can't get the product they want, but we're also not going to destroy the natural features of the community.
The reason that I just pointed out that second part about the vegetation, and if it's in the PSES, if we're looking at this as did the planning board act within the constraints of their board, the wording in that PSES thing to me says that the planning board had the authority. They could have granted additional clearing within that buffer if they deemed it suitable. If they deemed it suitable or appropriate based on whatever the developers had proposed. The planning board, again, for whatever reason they decided, said no, that they weren't going to approve that. And so I think I think that wording right there just illustrates that they were within their authority, operating within their authority to make that decision. I see what you're saying with everything else, is that there's an intent implied through several of the town's regulations and ordinances, but what we're trying to do is, if we're trying to look at something to hang a decision on here, we want to find wording like that one, in my opinion, that says the planning board has the right to do this, one way to make a decision here, and I like that wording there. They have the right to make that, and they chose not to.
If I can just focus the board's attention, just if you remember the arguments that were made on that first condition regarding the brush, it was that second paragraph of section C1 of the PSES was whether you read it as the first sentence regarding zone change as applying to the entire paragraph, or whether, as the planning board argued, that's not a reasonable way to read that. In other words, can that first sentence control the rest of the paragraph? In other words, is everything under that second paragraph restricted to zone change situations or otherwise? And, you know, either way, was it a reasonable interpretation by the planning board? And Nick and Maggie, if I'm incorrect in stating your arguments on that position, let me know.
I think you stated them well.
So just to be clear, so based on the wording from the PSES, that, I mean, just when he reads it, it sounds to me that the planning board has the authority to decide if additional clearing is done within that buffer or not.
I think that's a fair way, if that's how you want to think about it. Sure.
So, yeah, so I mean, the rest of the board can certainly chime in. So, I mean, so that's, I'd already stated that, I mean, Pierre just kind of reaffirmed my thought process, is the problem with these, or the perceived problem, is with that second paragraph, where it's talking about rezoning, but the verbiage throughout both of the paragraphs overlaps back and forth, whether it's zoned, rezoned, how it's zoned, it's all encompassing of the PSES. It's not just, we can't cherry pick out that an RFR 80 isn't going to use blasting, and we're not going to worry about air quality and soils and things like that. It just, that happens to be the intro of that paragraph, specifying that amount, you know, specifying those certain criteria on that area. The rest of it applies to the whole PSES. That's how the planning board looked at it. And, you know, in my own view, that's how I would look at it. The rest of you guys can chime in on that. Maybe we just stay on that, item 5 right now, because we're not really, we're not touching on the other appeal, number 26 yet.
I think the very first sentence of that states it all. All PSES shall be constructed and operated in a manner that minimizes any adverse visual, safety, and environmental impacts. All, not just rezoned.
But in just to support what you're suggesting is that the intent of, all, like I was mentioning, the intent of all this is actually, regardless of zone change or not, is to protect buffers, protect landscapes when applicable. Right. So I mean, it's when applicable, or not applicable, when possible, to the greatest extent possible.
I mean, that's what we're doing. We're looking at it from the planning's view and seeing if that's the way that they would read this, or if they would cherry pick this out and say, well, no, it's not an RFR 80 zone, it's not a commercial, it's not a manufacturing. So therefore, we're going to selectively grab sentences of this that apply and don't apply. That all of these would have subsections or bullet points to pull that out, and not all be encompassed in 2 paragraphs. It's all encompassing, and that's how I would assume that the planning board would view it. It seems like anybody would. You can't just select the cards that you want out of a deck to win. So I don't know if you want to have any more discussion on item 5. I don't know. You guys want to add anything else? Any more findings to that? Or? No?
Pretty clear to me.
Okay, all right, so as far as item 5, would we accept that, those findings and that deliberation as findings of fact for the record? I can only entertain it. Somebody want to grab that as a motion?
So moved.
Okay. We have a second?
I'll second it.
Okay. Any more discussion on that? All in favor?
Aye.
Okay, so if we move to, it was the appeal item, where the heck is it? It was on condition number 26. It's all site work shall be performed Monday through Friday between the hours of 8 a.m. and 5 p.m. Eastern Standard Time. So that one's another interesting conversation. That's probably more applicable when we get into the Hopkinton Code of ordinances. We go into sections 13.5, number 75 and number 76. So when we get into that, I'm trying to find this section in my notes here. So if we go into 76, in the first opening paragraph under item A, it says that the planning board shall set any appropriate conditions and safeguards in harmony with the general purpose and intent of all local regulations. And then it lists some, but not all, of the different things. It goes into like sidewalks and travel lanes for traffic, walkways, adequate drainage, erosion control, screening and fencing, and how it will enhance and buffer the premises. And then under item 9, it says mitigation of negative impacts as deemed necessary and appropriate in accordance with all federal, state, and local regulations. That's a huge broad stroke. And I don't know your view on that. I know in the past that as a zoning board, we've made conditions that have put time constraints on certain activities or projects, hours of operation. Under all of those ordinances, the guidelines, the PSES, a lot of the items I read, do you feel that the planning board would look at that and make a determination that the hours of operation would be there to protect the harmony of the community, just as a, right? Because you have people that, I mean, their homes are close by on Maxon Hill Road, and when you go, what's the other Frontier Road up in the back? I mean, if you're listening to that stuff, that project was slated to go on, I think, for a couple of years. I know where I live, we've been dealing with construction at exit 3, it's only a quarter of a mile away, I can hear it all day long. We've got other projects up further up Arcadia Road, up Dye Hill Road, Skunk Hill Road, and what they're going on with the house plats. They go on for years, and you're dealing with trailer trucks that are moving asphalt, gravel, moving building products, and there's a constant back and forth of equipment. And that's me living off of Arcadia Road, and these projects are miles away. And this project is right next door. If they start real early in the morning and work real late at night, and it goes on 7 days a week, when do our residents get peace? And I think that's where that last section, where it encompasses all federal, state, and local regulations, where local regulations will be sound ordinances, our zoning ordinances. At what point does a project become a nuisance? Not that it is yet, but a little bit of constraint on that can help it from becoming one. And I think that's where the planning board is coming from in my view.
Mr. Chairman, if I can just point something out, I think you said hours of operation, I think the constraint was on site work, and as I understand.
Yes, on
for
site.
the construction of the actual.
Correct.
Construction installation of the panels.
Yeah, to clarify, it was on hours of operation for the site work. You have more discussion on that?
I think there was a mention in there of just consideration of health. And I think that when we talk about health, we should consider people's psychological, emotional, and mental health. And I think the point that you made there, that these are long-term projects, and without restrictions, there can be continuous activity. And I think it could significantly impact, or at least it sounds like there's a consideration of that within these regulations. So I just thought that was worth pointing out as well.
Wasn't the question though just on Saturday work?
No. No, I think it was all hours of site work, not just on the.
Yeah, but it's limited to 5 days a week, where the discussion was they just wanted to be able to work on Saturday.
I think what you read was Monday through Friday, 8 to 6, is that, or 8 to 5?
They were appealing the condition, which was 8 AM, 5 PM Eastern Standard, Monday through Friday. There was no weekend hours in there.
That was the condition that
They're appealing that condition.
right.
Again, it's not our duty to look at, should the planning board have allowed Saturdays, do they have the ability to condition them? Right? They can, the applicant or the appellant could always go back to the planning board and say, that's too restrictive, we need to do this on the weekends under maybe a different set of hours, but that's the planning board's judgment, not ours. do they have the ability to put time constraints on it?
And I'm not sure, did anybody find it, read in the minutes from the previous projects that have been developed? Maybe there were problems, and that's why they imposed this time?
Well, if somebody could point me to it, I didn't find it where they had any discussion at all, or very little.
There was some discussion in there, I believe, somewhere in the transcript, Mr. Moreau brought it up. I think another resident or another planning board, I can't remember the name, it was a long name. She brought it up. Again, just as the zoning board does, or even this Board of Appeals, we do have a background in land use. Several of us have been here for a long time. We're aware of what some of these different applications and things that can get approved, some of the positives and negatives of them. And I would, you'd make the assumption that the planning board also knows they've handled several of these applications. They're getting feedback from the community as to the negatives, and that's where the sound, and the, you know, the site work constraints would be put on it to try to keep the use and enjoyment of the community's overall health and well-being in control. I don't think they're trying to hamstring the appellant. I think they're trying to find a balance with both. Right? So, any more discussion on item 26, condition 26? Want to add any more findings on that one? No? Entertain a motion to put that discussion and those findings into the record?
So moved.
Second?
Second.
All in favor?
Aye.
All right, lastly, I just wanted to have a discussion about this. I find this one interesting. This is about the solicitor's back and forth opinion whether the planning board has the authority to interpret the DPR. I know us as a zoning board, I believe how we feel, I know how I feel about this. Is it the job of the planning board or the solicitor to interpret planning regulations, the DPR?
It's a regulation, not an ordinance, right?
Right, so, I mean, again, if
And
we...
they have some latitude, I believe, compared to the zoning board, which we are kind of bound by the ordinance.
Again, though, our solicitor can make a recommendation if we're following letter of the law, and if we choose not to use his recommendation, that's at our own detriment, right?
Well, not really, I mean, they had to give an opinion. If you don't particularly believe in the opinion they're giving it, then the board has the ability to go with their opinion, right or wrong or indifferent.
Right, and that's how I feel these boards work. There's no point in us being here if the solicitor's going to make the ultimate decision as to how we rule on certain things, or if we have the ability to rule on them. The boards make the decisions based on their background and our own expertise. They're here to try to keep us out of legal trouble, but ultimately it's the planning board's decision on how they interpret the DPR, not a solicitor's. Okay? I mean, because that was an
I think
interesting...
we're agreeing, but you're not getting it.
No, I know we're agreeing. I'm reaffirming it because I like to talk a lot more than you do. You get right to the point. And I like to make her type a lot. And
Doesn't always make the boards right, it just makes them
Correct.
their opinion.
and it's scary, man.
The solicitors are only there as a tool, just like a book, like a computer. Sorry, Ken.
I've been called a tool before, so.
I love that.
The way I see it.
Okay, yeah, no, you're right. Would the rest of the board agree with that? Yeah. A lot of head nods, can we say it out loud?
Yes.
Yes.
It also makes the mistakes of the board their own as well.
Correct. Correct.
You know, if it gets challenged at a court of law and they lose, then
And that happens frequently from a lot, I mean, from whether it's council, zoning boards, other boards or commissions, where they get appealed, it goes to the state level and things get overturned, and I mean, that's the way it works, but, again, I think a solicitor is there for an opinion, it's not, they're not there to make a decision, but the record made it seem like the planning board and the solicitors were all going back to the town solicitor to see if they could do something, and that didn't seem appropriate. I mean, there's nothing wrong with asking them, but it's not the solicitor's decision.
Well,
It's okay.
in some cases, I'm not stating this case, but in some cases, the solicitors get way too involved, where the board should be doing the jobs.
So just to be clear, the point that you're making here, as it's relevant to this, is that the planning board, in interpreting some of these ordinances, were within their authority to do so.
Yes. Yep.
Or actually, what he's saying, even if they weren't, it's still their decision to make, right or wrong. And if it loses in the court of law, it loses in the court of law.
I think the
Or if it's
distinction that I'm trying to say is,
You're both right.
they are within their authority to interpret these. They may interpret them wrong.
Incorrectly.
Incorrectly.
Which has happened on
And
both
that's why we
boards.
have, and our solicitors are there to guide us on this. But it is within their authority to interpret these regulations.
Yes, the planning board to interpret
Yes,
them.
yes.
That's their duty, that's what their job is, as well as ours. We know what our job is tonight, I mean, we all knew it to begin with, but it's restated it several times tonight. So,
Yeah, whether we personally believe they did the job correctly or not, we're doing the facts that we were provided.
right, we didn't sit through how many months of testimony did I read off in that?
I would say hours.
Yeah, no, they were in months, I mean, they went through
Right.
6, 7 months of testimony. We didn't, we reviewed it.
But we were also, we have a very narrow task. Of them two items, did they rule the way the town ordinances read and regulations? Whether
Okay, so can I
we
entertain?
like it or not.
Any more discussion on that topic? Any more discussion in general? Could I entertain a motion to put that last bit of discussion as finding into the record?
So moved.
Second.
All in favor? Aye. Okay. One of you guys like to throw a decision out there?
Undecided.
So it would be, the decision would be that the planning board had the authority to make the decisions they made for items 26 and, I'm sorry, I don't remember. the
Let's
number.
break them out separate and
Okay.
make it into two, because we may feel differently about the both.
Sure.
So we have condition number 5, which
Just
is,
to jump in as a
ahead.
tool. Thanks, tool. Essentially, you either uphold the decision or reverse the decision and remand it with, or amend the decision. That's really what the scope of the decision is. You either uphold the decision, vote to uphold it based upon the findings of fact and conclusions that you've gone through already, or reverse it and remand it based upon, again, all the information that we just went through.
yes, no, correct, correct.
Just
So condition 5 was based on the vegetation. So could I entertain a motion to uphold the planning board's decision on condition number 5?
So moved.
Can I get a second?
Second.
Second, Dan, any discussion on that? All in favor?
Aye.
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 Okay. So then on condition number 26, which was the hours of the site work, could I entertain a motion to uphold the planning board's decision on condition number 26?
So moved.
Here's a second.
Second.
Any discussion on that one? All in favor?
Aye.
Aye?
Aye.
Okay, that's the decision on that one. We're upholding the planning board on both conditions. Okay? So we'll move on to, thank you. All right, we're gonna move on to
So am I active on this?
Yeah.
Mine just is
Yeah, can I entertain a motion? Can I entertain a motion for a 10-minute recess?
Second.
All right, all in favor? Aye. Okay. Dan left, yes. If Dan's still here, no.
Right.
I think he was here, but I don't know if he was.
Yeah.
He was staying, he said,
So
Might be
I,
outside.
you're officially fired.
No, not necessarily. He might be outside yapping, but,
I can grab my other bag.
yeah.
I'll see if he's out there.
Yeah, if you see him, give him a nudge.
I don't agree with it, but,
No, if we sat, we might be
well, you
different.
could have made more of an argument on the hours. They should have been allowed to work Saturdays, that's a normal construction job.
yeah, but I guess what you're saying is whether it's up to the planning board to decide that or not. So
Well, they didn't put up a good argument, is my point.
So their whole point, Reveille's whole point was that it had to be based on specific objective criteria in the zoning ordinance, which incorporates DPR. So the question is whether all those considerations of public health, safety, and welfare are specific. Objective, and basically, whether or not that's specific.
This? No, I can,
Was that?
I think I have a copy of this thing.
And he's like, that's it's subjective, that means that's not objective. You know,
She can just make a copy of it, man. Is that what she said?
She was gonna have you.
I was just trying to.
Oh, you know what? No, I don't care if you have it. I can scan it with my phone, and then I have a copy and I can forward it to her.
Point being is, construction works Saturdays, but most all the federal and town and state projects are 5 day a week. So they can get the job done in 5 days.
Best app ever. I'll scan it.
There wasn't a lot of discussion about it. Convert to PDF. I saw.
No, there wasn't. That's right, Joe Morrow brought it up in one of the hearings, and then.
But that's my point being,
No, they didn't.
so if you didn't put up a fight,
And they were claiming that they were hamstrung. They didn't.
I also don't know how to stop recording that, so
Before they could.
keep that in mind.
argue it, but
we're off, right?
No,
they had the opportunity.
yeah, I know. How much time did they
It was
get?
over. I mean,
No, I'm just,
nothing they were saying is changing the decision.
no, I agree.
But anyway, that's the argument.
Why is
Yeah, we
this
gotta,
not
we
here?
gotta get turned off during our research.
I know.
I'm sucking the air.
I know.
You know how I am.
It's your fault.
I think I just. So,
It's probably going into like the computer sound.
This is the voice of
don't
God.
stop the reverb again. I had a hissy over there. I'm gonna give her this, the same thing. There are footnotes in there that they're on my own notes that I typed in, and then it's handwritten ones. So that I can say, but you'll be able to cross it over. I'm gonna say.
You have to. Yeah, because if someone got sick, you have to fill in.
Well, for sending, this was all out of the ordinance. So I know a lot of this is out of the ordinance.
Nobody explained that to me.
I mean, everything in the highlights I read. Everything was not reasons, I skipped. But then I removed from where I was highlighting and I went to pen. So everything that has a mark on it, I didn't mark it. So when I tried to get these guys to understand the whole process, I just started. Sometimes the squirrels up here.
So yeah, that's your job. And you have to move to somewhere else.
That's all down code and everything.
Yeah, which I can look at easily. That's fine.
Thank you, sorry I go, you're probably used to it, but.
Yeah. I
Every second, something to get with their.
Sounded okay? You just hear like dolphin?
I heard again most of all.
He spoke
He was laying it in.
Yeah, he was speaking clearer than you. I've been there several
Really?
Well, he was laying there on his mic, I don't care about it.
Yeah, but you're very loud.
He was tone deaf to listening. Yeah, no, I know.
And I didn't hear any of the paper shit.
The planning board's got a big plan, and everybody starts moving them, so it's just gonna sound like it's just paper chips on one side.
It's a very limited deal.
It's just two items, and it's really just. Did they apply their things in a manner that makes sense? Right? It's hard because we can't judge where the Army's like, I don't like the hours, that's fine. Can they do that? We condition hours of operation. We have that right. They do too.
How about his date on the solicitor?
That was a good tool. Always. This is going on. It was funny. That's funny. Paraphrase the two. So that's,
Thank you. You're my chair. No, I just... No. He's got me on a tight leash with these maps. Can you see all that? Yeah, I got glasses on. Yeah, me too. Yeah, but you haven't changed that prescription in probably 20 years.
No, I always unlock my phone. But thank you, John.
I see it on here.
That's right.
The crazy town, Dan? Crazy town?
How about you?
Tuesday, the loudest, and
Yeah, that's right.
All I do is, I put out fires.
Hey, did Robert Bruce know? Well, no, that gave me that frame.
This close.
really?
Not him.
It's just whether or not you read it one way or the other.
Really?
Kevin's still there, yeah.
You gotta kidding me. You hired an attorney out of Providence now.
What?
You hired an attorney out of Providence.
For what?
Specific.
You can get older. Yeah, we talked, yeah, like here, but I'm handling the,
Real estate agent. Okay, yeah.
well, what's his, but he's got that other guy, right?
Jeff.
That's a surprise. What's the issue though with Jeff?
He's still waking up at night.
Close. Not really. It's not easy to get along.
Oh, because you're gonna get home late, you're gonna get your pushes all, and then talking after. Yeah, two personalities.
I go to bed at 7.
Great on each other.
Thanks for sticking around. I don't know who that is. It's off the top, it's not me.
That's good.
A little entertainment.
I just want to see how it sounded from the other side. I mean, I wanted to see, like, you can't see.
I've never tried it. I don't think that's what I'm doing.
Yeah. Yeah,
I get
that's
upset
right.
because they're like, really.
Chip, you can sit back here in case you want to chat with us or anything. You don't have to sit out there. Got a few out there?
John, did you sign the waiver of decision?
No, it's just like, we can bring it.
You know, like, nothing, like, recollect nothing.
It's helping you out. Thanks for helping out. You would have
This is funny.
Then
I'll send it in the morning.
Jonathan said, stop by next week and sign it, and I never saw him, so.
No, I assumed it was here and I was gonna come sign it. Did you send it to Sheila?
you still,
You can sign it.
Are you still in color? I'll go down and look for it and I'll sign it and then I'll bring it. I figured I was, I got so late, I figured I just signed it.
I know, I wasn't thinking.
It's better than email.
that's an accomplishment if you can.
I'll print it out.
It really is,
Well,
especially nowadays.
Come down.
This transition
and sign
this
it
year
here.
Yeah, I can do it in the morning. If I don't come in tomorrow morning, remind me. So
Those are what we do
Okay.
next?
Because I'll, honestly, I'll call it just.
That's right, I'll give you a call some morning.
So you're gonna go to the Troop of the Club?
Sure.
You guys run the Troop of the Club, right?
I take advantage of that. That was a good conversation.
We're trying to get the one-on-one.
All right, guys, you ready? Yeah.
I didn't know it.
Entertain a motion to reconvene?
So moved.
Second.
All in favor? Aye. All right, we're here for petition 2, which is a petition filed by Peter F., forgive me if I mispronounce it, Squires? Yes. Esquire, on behalf of Tom and Cynthia Skolko on an appeal of the decision of the Hopkinton Planning Board, appealing the decision of the planning board granting the approval of the master plan application submitted by R595 LLC for a large-scale photovoltaic solar energy system located on property identified on the Hopkinton Tax Assessor's Map as Plat 11, Lot 47A, addressed as 0 Palmer Circle, Hope Valley, Rhode Island, 02832, in accordance with RIGL 452367 as amended. Appeal was made subsequent to the former RIGL reference in Article, what's that, 15 of the Hopkinton subdivision regulations. We have the applicant is present.
Good evening, Peter Squires on behalf of Thomas and Cynthia Skolko. And we are here appealing a decision of the planning board back on July 21st. The planning board voted on a 3-2 decision to approve a master plan approval for a 81-acre solar project on Plat 11, Lot 47A. So that parcel is zoned commercial special. It's not a commercially zoned parcel, it's a commercial special zoned parcel. And in the zoning ordinance, section 4, states, that's where it sets out what it means to be in a special zone. I'm going to quote a portion of that. It says the zone, quote, which the town council imposed use limitations, conditions, and/or restrictions, end quote. So right away, when you know you're looking at a commercial special zone, it's not an ordinary commercial zone, it's got conditions on it, limitations, restrictions. So, question is, what are those limitations and restrictions? And if you go back and you look at the minutes from when this parcel was rezoned back on July 2nd, 1990, that the conditions are listed there. That parcel was rezoned at the request of an attorney for the property owner for what was referred to as the Brayburn project. It was going to be a mixed-use project with a hotel, golf course, some residential. And if you look back at the minutes of that council meeting where it was rezoned, it lists, it starts with the motion to rezone it, and it goes paragraphs 1 through 10, and it lists all the reasons why they think that that project would be good for that parcel. You know, why they think the hotel and the golf course is consistent with the comp plan, all those sorts of things. Then, you get to paragraph number 11. And that paragraph says that the zoning change is, quote, is granted subject to the following restrictions, end quote. And then it lists those restrictions. So, right off the bat, you know you're in a commercial special zone. What are the restrictions that go with that? They're listed in the minutes of the meeting, right after paragraph 11. Paragraph 11B, which is the relevant restriction here, says the maximum number of structures and the uses in this zone permitted in connection with this project shall be as proposed. 1, hotel, a conference center having a combined total of 200 rooms, one country club, 165 units of residential housing, and one 18-hole golf course. So, you have a commercial special zone. It has these restrictions. It says there's a limitation on the uses allowed in the commercial special zone, and then listen, nowhere in that list does it say solar. So, our main argument here tonight is that the commercial special zone that this project is zoned is limited to certain uses, and those uses don't include solar. So, if there was any ambiguity on that point, if you go back and you actually look at the meeting minutes from the planning board, and this is the March 14th, 1919 planning board meeting, where the planning board actually gave a recommendation to the council saying, you know, should you or should you not rezone this? And the property owner's attorney was there, and it says in the minutes, and this is in your packet, it says, quote, Mr. Nacarado, that's the attorney, Mr. Nacarado stated that they are seeking to permit specific uses allowed in a specific ordinance for a particular ordinance. I think that was the state of the minutes. There is no intention, that's not intention, but that's a typo. There is no intention of picking up additional permitted commercial uses. So, you know, to me, that makes it as clear as day. It's a common practice. Someone wants to come in and get a rezone to develop their property. They come to the planning board first. They need to get a recommendation. As it often comes up, they're asked, if we rezone this, are you going to change it to something else? And the attorney said, nope, we're not. We want this. So then they go to the council, they get the rezone. The rezone has that limitation that I just read to you, and it's marked out as a commercial special zone. So, the question asked, and as I stated earlier, on a 3-2 vote, it was approved for a solar project, not included in the list. Well, the applicant's attorney made an argument for why that would be allowed, and I'm looking at his brief that he submitted for this on page 9, and what their argument is that that these limitations applicable to particular proposed projects do not mean that other projects cannot be pursued involving other uses permitted by the zoning ordinance that have nothing to do with the previous proposal or its uses. So, I think it's important to stop and think about the implications of that argument for a minute. Take, for an example, recently, there have been a lot of rezone proposals from developers and property owners to rezone their parcel from residential to commercial so that they can have solar. You know, it's a process that the town's familiar with at this point. And in that process, when those properties were rezoned from residential to commercial for a solar use, invariably, the property owner would say to the council, you know, this is what we want a limit to this, and then they're asked, do you want to do something else there? Are you going to put a shopping mall or you know, a Costco or some other commercial use if we zone it? The answer is always no. You change it to this, we're limited to this is all we want. Now the argument that the developer is making here is that that limitation only applies to the project. It doesn't stop you from doing anything else. So what they're arguing is, by having a commercial special zone with limits on a project, the developer comes in and says, hey, rezone this for me, I have a particular project in mind, and I'll let you limit it to that. What the developer is saying, yeah, that just means for that project, you're limited, but you can do anything else. To me, I think that interpretation is clear error. There's more to it that we'll get to. How did the planning board vote on 3-2 to approve that based on this argument? I think it goes back to a comment that was made on the last application about who makes the decision when you're interpreting the zoning ordinance, solicitor or the board. And I think there was a prior initial legal opinion from a prior solicitor in 2011. And essentially, that legal opinion from that solicitor in 2011 gave a legal opinion about that, basically the same argument that the developer made to the building official, and the building official wrote a zoning certificate and gave it to the property owner at the time. So then, this developer comes in, they ask for another zoning certificate, and based on that prior decision from a prior solicitor, they gave it again. And then it comes to the board, and we argue this again, and your last solicitor, who just recently left, he advised that again. So you do have, even though I think it's pretty clear that if a developer comes in and says, I'm going to limit my project to this, that you have to limit it to this, you do have other lawyers that have said, and they're not here, well, no, that doesn't mean you're limited to this. It means you can do anything in a commercial zone, but if you do this, you have to limit it, how it says. I don't think that makes a lot of sense, but that was the argument. So our first argument, I guess I'll break this into segments to break it up and make the ask that we're asking you easier. Our first argument is that, putting everything else aside, it's clearly, it was clear error for the planning board to approve a solar project for a commercial special zone with this limitation stated on the rezone when they rezoned it. Understanding that other attorneys gave other opinions in the past, we still think it's pretty clear. If you come in and you say, we're going to limit to this, you got to limit to this. Second error, and relatedly, how the planning board got to approve it. So before they voted on July 21st on a 3-2 vote to approve it, back on May 5th, they took another vote. They voted that the motion said the doctrine of equitable estoppel prevents the town from changing its mind now concerning the lawful use of the property for solar. So that was the motion that was made on May 5th. They said they were bound from changing its mind, and they voted that they were bound by equitable estoppel. So our next argument is they shouldn't apply equitable estoppel.
Can I interrupt you for a second, Attorney? Could I give the board a chance, you're going to go so deep into the weeds, the questions are going to get lost. So if any of the board members would have any questions for Attorney Squires, let's throw that out on his first argument. Yeah, go ahead.
I got a quick question. You said that 2 other zoning certificates were issued for different use under that zone by 2 different town attorneys?
There were, yes.
Okay.
Anybody else have any? Dan, you have some?
You're spending a lot of time making a distinction between a general commercial designation and then a commercial special, correct? That's the basic premise of the argument. And towards the end, you had said that certain property owners going before the council made representations to the council that they planned on limiting that particular use. If that in fact is the case, then why would we need a distinction between commercial special and commercial? Why wouldn't the approval, the initial approval, simply been a zoning change to commercial with limitations?
So that's what the commercial special is. So if someone was to come before the council and ask for a commercial zone, and the council puts limitations on it, just so that they know it's not a regular commercial zone, they'll call it a commercial special zone.
But this commercial special travels with the land and not the owner, correct?
Correct.
So somebody could have came in the future, proposed the same exact project that that particular applicant abandoned and be approved without going before the council, correct?
Correct. That's the approval for the zone.
What would happen if that subsequent applicant came in and made a modification to the plan? Let's not say increasing use, let's say limiting use. Say hypothetically they pulled the golf course out of that approval or plan and went with the remaining elements of the initial approval.
So I think they can do that, because it says the maximum number of structures and uses is, and then they give the list. So that means that's the most you can do. If you're doing less within that list, then you'd be within the terms of the limitation.
When you referred to the minutes of the council meeting, you referred to 11B.
Yep.
And in 11B, the council specifically said with regards to this project, correct?
Yeah, so I have, it's the maximum number of structures and uses in this zone permitted in connection with this project shall be as proposed.
But they made it a point, when they said it, that they specifically said this project.
Yeah, I think that what they were saying was in this zone, which is the commercial special zone that was created, they're allowing a maximum number of structures of use in connection with this project, because it's clear from the minutes, the only thing they contemplated would be allowed on this rezone was this project. So in this zone, with this project, this is what's allowed. If they were rezoning it to allow for any type of commercial, there would have to be, you'd imagine, there would be some discussion about, well, what are the other types of commercial uses? There's not. What they were attempting to do was read the zone at the request of a particular attorney for a particular developer for a particular project, and that's the language they use.
Besides the minutes from that meeting, have you come across anything else relative to their approval that would spell out in greater detail or definition the boundaries or the limitations on the approval?
Now, the meeting minutes are where the conditions are stated.
Didn't the solicitor Romano, when he issued his opinion, which was very similar to Mr. McAllister's, didn't they rely on a reference to the fact that that approval referenced the ordinance and incorporated it by reference as a basis for them to suggest, or for their opinion, that the project or the solar project as proposed would be permitted?
So they relied on the fact that they relied on the fact, first, they attached that exhibit to the minutes. Then, on top of that, they placed the restrictions that were stated in the minutes that I just stated to you. But even if you were to look at that attachment without applying the restrictions that go to it, it lists uses 1 through 16, and then it had another, last use that said anything else, you need to get a special use permit from the zoning board. There was no solar on that either.
I just didn't see, I couldn't see, or didn't see anywhere where they made reference by, they incorporated by reference. I didn't see that in the minutes. I didn't see that in the planning board minutes. So I'm wondering where that came from.
That's just how the ordinance was kept. in the clerk's office. So I think you're right, there's a question on that, but I don't think you need to reach that question because, we all agree that the restrictions stated in the minutes apply, and the restriction says maximum number of structures and uses in this zone permitted in connection with this project shall be, and then list them. So in my opinion, even if there is a question of, where that got placed in the file and how, that condition says everything we need to know about what the permitted
Also
use
says
is.
this project.
I'm sorry, Mrs. Spock.
I said it also said this project.
The planning, you referenced the planning board minutes, but those would be advisory. In best case scenario, those would be advisory only. Would you agree?
Yes, the planning board's recommendation is advisory, but beyond that, that's a record of what the applicant stated and what they were, this was a rezone at the request of an applicant. And so the applicant stated, this is what we're requesting. We're not requesting any other commercial uses. So if the applicant comes in and says, hey, we're asking for this use and no other uses, I don't think you would expect that the council would say, oh yeah, and by the way, here's all the other uses in the commercial zone.
But it appeared to me that Attorney Nacarado was struggling between the concept of a PUD or a future ordinance concerning a PUD versus the cluster development, restrictions. And that's why he made that represent. I mean, I don't want to put myself or try to guess what he was thinking, but that's what it appeared to be.
Well, I think you're right in the minutes. It says he didn't want to get a planning board review under the PUD, which hadn't been passed at that point. But nonetheless, he made the representation. There's nothing in the minutes that says he took it back, and there's nothing in the minutes that says that the council was going to be giving all the uses in the commercial zone. And even if you look at the findings for why they did the rezone, look at 1 to 10. Now, those aren't the restrictions, but those are the reasons that they're telling you why we're doing this rezone. And every single finding, 1 to 10, they're not saying this is a great spot to have commercial generally. They're saying this is a spot that's good for this project.
Thank you.
Is there any other questions on the first argument? No? Well, I think you were in the second, maybe third.
So, second argument is, the planning board made a motion on May 5th that they were bound by the doctrine of estoppel to make the finding they did. First question, what's the doctrine of estoppel? Basically, it's just a fancy legal word for if somebody says something, person A says something, person B relies on it, then person A can't change what they said. What were they basing estoppel on here? Well, the motion said, quote, the applicant requested and received verbal assurances from town officials, including the planner and zoning official, based on prior legal opinions issued by town solicitors of the property which would be used for the commercial use. So essentially what they're saying is, these town officials, planning and zoning officials gave assurances, and now we're bound by those assurances, we can't change it. And I think you identified the problem with that, because the town officials, they're not the ones that are ultimately responsible for interpreting this provision of the zoning ordinance. So when the planning board said, we're bound, we're stopped from changing what they said, that was an error. And there's legal case law to support that, because the issue here is that when you're talking about estoppel with a municipality, it doesn't apply in a case where a municipal or any government official doesn't have the authority to make a binding promise. And so the case on that's kind of the case that's been led to a lot of other cases. It was a retirement board case. And an employee retired from a state job, wanted to get another state job, and And before he did, he called up somebody that worked on the retirement board and said, hey, if I get another state job, can I keep my pension? The person on the retirement board said, yeah, sure, you can keep your pension. And so then he got the next state job. Well, it turns out the law didn't let him keep his pension. And so he went to court when they tried to take his, stop his pension and said, hey, wait a minute. That guy in the retirement board system promised me that I wasn't going to lose my pension. Now you can't take it back. And, if you just apply normal stop rule, you might say, hey, it's unfair to take it away because, he did get this promise from somebody that works at the retirement system, he should be able to keep his pension. The court said, no, it doesn't apply in that case because a government official doesn't have the authority to change the law by making that promise. The law is, you get another job, you can't keep collecting your pension. And even if that guy told you that you would be able to, well, it's tough because he can't change the law. Now, there are cases that apply that principle to zoning certificates or building permits even. Building permit, go out and build. You can start building your project from local zoning and building officials. One of the cases we cited was a case where someone got a building permit to go build an asphalt plant in Johnston. And they started to build. Now, in that case, I know that your planning board solicitor pointed out that there may have been some political shenanigans involved. But that wasn't central to the holding of the case. I definitely am not suggesting that's the case either. But what the court said was, so you started building your asphalt plant based on a building permit that the other zoning official gave you, but it's too bad, because that building permit didn't follow the zoning laws. And the law's the law. Everybody's supposed to know what the law says. Another case...
I thought they finished building that plant, though. They did finish building that plant, so apparently you're not correct.
Well, at least that's what the court said. What they did after, I don't know.
Well, they finished it, so apparently they won.
They
No. I just know it got built, so.
maybe they got a zone change. And that's something that could have happened here. If the developer thought this was a good place for solar, they could have asked for a zone change too. Because the ultimate authority for deciding that could have taken this restriction off is the council. The council at any point could have just amended this commercial special zone and said, you could build a hotel, you could build a golf course, or you could build solar. But who can't do that, and the case law is clear they can't do that, is a town solicitor or a building official. So, and if you think about it, you have two scenarios, basically. There are two possibilities. You have the zoning ordinance that's in front of you, and someone comes in and says, does this allow for solar? And the building official either says it does or it doesn't. And the zoning ordinance either allows it or it doesn't allow it. If the building official says that yes, it does allow it, but the zoning ordinance doesn't allow it, then you can't apply stop order, because what the building official told you was wrong. But if the building official says it does allow it, then, and the zoning ordinance actually does allow it, then you don't need a stop order, because you just apply the law for what it is. You're not basing it on the promise you got from a zoning official, you're basing it on what the law is. And like you said earlier, the board with the authority to interpret the zoning ordinance in this case was the planning board. So they shouldn't have voted to say they were bound by a stop order. Now, what did it do when they voted they were bound by a stop order? It affected their ultimate opinion in the case. And I would look at the vote that was taken on July 21st. And this is the transcript of the July 21st meeting, page 93. And this is what the Chairman DiOrio, the Chairman of the Planning Board, said when he voted to approve. And just as background, he was actually on the Planning Board when Brayburn was rezoned. So he knows what happened. And this is what he said. He said, this is Al Diorio. I was conflicted when this project first came before us. I was perhaps the only planning board member who was actually a part of this initial rezone application. I was more than a little disappointed when this project came before us. I really didn't feel that it belonged here. I didn't much care what the legal folks had to say. I was around, and they weren't. So I felt that I knew best. And this wasn't a fit for me. Okay, so that's how he starts it off. And the way I read that is he says, I was here. I know what this rezone was about. This was about rezoning it for the Brayburn project. But then he goes on. And this is when he comes around, and he does vote to approve the solar project, and he was the final third vote. And he says, however, I was then reminded that the horse had really left the barn on this particular topic, and I would recite or would direct your attention to items 4 and 5 in the decision of the solar applications and projects have been approved on this very parcel well before this applicant has arrived on our doorstep, and although I didn't participate in those proceedings, the time for the fight that has been raised by the opponents would have been much more appropriate when those applications were before the planning board, because then cogent arguments could have been made that this use does not belong on this property. However, that's a done deal, and that was the one of the pivotal arguments that brought me on board with this project. So, and I'd like to pause on that for a minute. He said, I was there when this law was enacted, and he was disappointed to see this because, you know, when you're there and you know what happened, I think it's pretty clear from the record that this wasn't supposed to allow any commercial use. But he said, well, the horses left the barn, and he mentions things that, where he said, well, you should have raised the argument back then, but we never got notice of any of those things that happened. I think that's an important point, too. 2011 zoning certificate, there's no public notice on that. The zoning certificate they got when they came in, that's not a public notice. Any assurances from local officials, that's not public. You know, that's not a public hearing where people get to come in and argue, well, this is the way I think it should be interpreted, and that's the way I think it should be interpreted. You know, that's just an official saying, here's my opinion. And that's all it is. It's one opinion. So I think the planning board voted on May 5th that they were bound by a stopper. And I think that that vote on May 5th made the chair feel that even though he was there when they rezoned, and even though it's clear from the record that the rezone should not allow solar, he felt that he was bound. He felt like the horse had left the barn, and I think that was a mistake. So to conclude, or to finish the second part of my argument, what I would ask is, I'd also add, and this is more of a technical legal point, before I finish this part of the argument, you know, there's case law that says zoning boards, planning boards, they're creatures of statute. Their jurisdiction is limited to what's stated in the statute. And as I'm sure you're familiar, you get an application in, you get so many standards, and you look at those standards. The planning board doesn't have, you know, what they call in a court general equity jurisdiction, where you can go into the court and say, you know, do what's fair. Use your equity jurisdiction to do what's fair. So I don't think the planning board had jurisdiction to decide to stop it in the first place. You know, that they shouldn't have been saying we're bound by a stop on one of these critical findings, which is they had to make, is this consistent with the zoning ordinance? They should have just gone straight to it and said, is this consistent or not? And here's what the zoning ordinance says. Does it allow it? Does it not? That should have been the question. So the second argument that's an alternative to the first. So the first one I ask is, you know, the big ask is remand it back to the planning board and just say this is a commercial special zone. It doesn't allow a solar use. The second ask, which is a lesser ask, is at least remand it back to the planning board and say, don't apply a stopper. You shouldn't be applying a stopper. Take a look at it again and look at the zoning ordinance and see whether or not the text on the page, which, you know, that's the law, the text on the page, just see whether or not that allows solar or not. I would submit that if that was the way you approach this, that that is pretty clear, it doesn't allow solar. So that's the second argument, and if you want to take a break, we can get one.
Gentlemen, any discussion on that or questions?
I was going to ask you initially if the answer on your first point was that the board disagreed with your position. Would that make the estoppel argument moot?
So I think if the board had said that when you were voting, well, so I would say this. I don't think it would, because one of the reasons you can remand is for a prejudicial procedural error. And the fact that they voted on estoppel, they said they were bound by estoppel at the May meeting, and then they came to the June meeting, and they, and at least some of the members voted in a manner that indicated they were actually applying that estoppel argument. I think what you would have to do is remand it back, and you know what, if they made clear, you know what, I'm not applying estoppel, but I just disagree with you, and I'm going to vote against you, then I think the estoppel argument is off the table. You know, but at this point, I don't think it's, I think the fact that they voted they were bound, you know, there has to be something to make clear if they're not applying it. And if you look at the record, I think it's clear they are applying. They felt like they were bound. So I would just say, if you want to just take that off the table, remand it back, tell them don't apply estoppel, and just vote on it again. You know, look at the ordinance, vote on it again. And if at that point they vote on it again and they disagree with me, then it'll be off the table.
But the second vote doesn't make it clear to me that they used it.
Well, you know, I think the fact that they voted on the first vote, you know, if they had just discussed it,
But the final vote's the one that counts.
well, I think the first vote's got to count for something.
No, the final vote counts, and they didn't discuss it at that point.
And I would answer that, I'd answer that in two ways. Yes, the final vote is the vote that gave them the approval. But, you know, if you're on a public body and you vote about what your procedures are going to be, then you're stuck by the vote of the council. You got to prove, or you're stuck by the vote of the body. You got to go by what you voted to proceed. When they voted on May 5th, they didn't say, you know, we're interested in this argument or we're considering. They said, we are bound. We are bound by the doctrine of estoppel, and then they voted, and that vote passed. So if you're following the rules that they're setting out for themselves, at that point, they are bound, and that was an error.
But they were fully within their rights to reverse that decision in the last vote.
Well, I think they'd have to make clear that they were reversing that decision. And I don't think they're right. I don't think they're right.
Let's take it on all in.
Yeah, no.
If estoppel was in play erroneously, they would be looking at it like we would as a finding of fact, right? If we erred in a finding of fact and found out inadvertently that we used that as a finding of fact, we would have made a wrong decision, because that would have hinged, despite what our final, the outcome is, I mean, that's what your argument is, right?
That's the argument.
Just clearing it up in my head. Okay. We're taking it down.
It's hard to look behind a vote, you know, even to a transcript, and find some meaning to what he said, or the meaning to what he said. Because clearly when that original project was approved, he wasn't on the council. And his reference to the fact that he didn't like the project, I'm not sure if he's referring to the original project, because it was so massive at the time. Any of us who lived here in the town at that time knew that that was probably one of the biggest projects ever proposed for the community. So,
So I guess my answer to that would be, if you think it's not clear, then there's an easy way to get clarity, and it wouldn't take very long. It would just say, put it, if you remand it back, it's not like we have to go through all the hearings again. They just put it in front of the planning board, and they take a vote. And if you tee up the question, then you get clarity.
But the other factor is that Mr. DeOrio doesn't go with the flow either. our experience with Mr. Diorio is if he believed it was dead wrong even the second time around, that's the way he would have voted. I'm just gonna throw that out there because I know him very well. And he's been on both sides of a lot of controversial votes.
You know, that may be, but
Well, I'm just referencing that because you led up to how he thought, his thought process of voting, but
yeah, you know, I would think, I think looking at the transcript is helpful. I think you're right. It's not like it's perfectly, you could look at it different ways. To me, that's the way I read it. But I
And you
think.
feel that's enough, you feel that's enough to send it back and say, listen, we need some clarification, everybody needs some clarification.
I think that, coupled with the fact that they voted on and said they were bound by something. You know, once you say you're bound by something, then you're bound.
not in the second vote.
I think they have to, you know, it's like if you create rules of procedure, right? And you say, you know, we're only gonna do this way. If you wanna get out of that and do it differently, then you gotta take a vote to remove it from the rules of procedure. This is similar. They voted and said, we're bound by estoppel. If they wanna not be bound by estoppel and do something differently, then they gotta vote and say, we changed our mind, we're not bound by estoppel. But I think at the very least, that was a procedural error for them to vote and say they were bound, and I think it was prejudicial, you know?
So the argument could be made that they corrected it in the second and just had a plain vote and didn't reference it. Because if it went your way, then there'd be another set of attorneys that are here arguing the other way.
Well, I think, I would say that either way, you know, because you can't, once they voted and said they were bound by estoppel, you can't go to the ultimate, you know, reality and figure out what would happen if they weren't bound. The only way to clear it up is to say, hey, when you voted and said you were bound by estoppel, that wasn't right, that was wrong, now tell us what.
Or you go by the second vote and say, they knew what they were doing.
At that point, you're making an assumption that you don't really know.
Yeah, as well as you know from the first one. Yeah, there's no arguing that point.
Should I move on?
Could I ask one more question? It appeared that both of those zoning certificates, well, first of all, is there a case law right now, recent case law that says that the zoning certificate cannot be relied upon?
There is, and actually, you know, I have that case law, and I'm going to pull it out and hand a copy to opposing counsel too, just so, you know, they have it as well.
And I couldn't find the other stuff. The country stuff is in next to it. And the country stuff, so they have a commercial special. Join that one giant use the garage restaurant. Because the truck stop.
I could actually hand this to your legal counsel as well.
So they had to get very specific.
My question with regards to that was that it appeared that both of those zoning certificates were issued after the
Or did they just make it?
individual, or the building official requested a formal opinion from the then serving solicitor, correct? Did you see that?
No, I didn't see that the solicitor gave an opinion.
On both, correct? 2019 to Mr. Dobbs, and then prior to that, Mr. Romano.
That's correct, yes. But
That's fine. I understand the concept of the estoppel. I guess my question would be, in your opinion, is there anybody on the town level, if they had made that representation, could bind the town? Unofficially, outside the scope of this, a formal setting like this, an administrative hearing or another approval?
I don't think so. I don't think so, because what the process is they apply, they come to the board, and they say to the board, look at these factors and approve me, and everybody else in the public at that point has notice. You can't go before the notice goes out, have a town official say, you know what, you're good to go on this. And then go to the hearing and have the board be bound. it's got to happen at the hearing when everybody has notice and everybody can argue. So that's my point. And, just cite the case law. So there's a 2010 case, Parker v. Byrne. Hold on. I have it down in here somewhere. And that's where the court said, so that was actually before the 2011 certificate issue. This is from 2010.
Can I interrupt for a second? Instead of giving me a copy, you can just give one to the chair, just so I can follow with you. Thanks.
No, I'm going to read from this one, then I'll hand it in.
Right.
So it says, this is where the court just said, we recognize that a zoning certificate is not legally binding. So that was just a sentence in that one. Then there was a Superior Court decision from 2003 from Judge Hurst, and this is where she said, neither a zoning official nor a zoning board of review may lawfully issue a zoning certificate for the purpose of making a binding or enforceable determination about whether or not a proposed use, structure, building, or lot would be legal under a municipal ordinance. Given the language of the pertinent sections of the Zoning Enabling Act, it's clear that the practice of attorneys and landowners to request a zoning certificate as a means of gaining binding or enforceable administrative approval is wholly unavailing, and is particularly so with respect to proposed uses or development, and the endless hearings and litigations that have been spawned by the misuse of zoning certificates or misunderstanding of their significance is time poorly spent. So that was the Superior Court decision on that. I'll hand that.
There's one more recent than that, isn't there, correct?
There is, as well. I don't have that one, but I do have these two, which were actually before any of the zoning certificates entered into this case.
Thank you.
Thank you.
Want to mark that as an exhibit? What do you want to mark?
I wouldn't mark it as exhibit, it's just authority, it's not.
Okay.
So if there are no further questions, I'd just quickly go to our third argument.
I'm good. Okay, fire away.
So our third argument, I don't feel comfortable making this argument, but because it's an awkward argument to make, but I feel that I have to make this argument because I think there was a serious error of process here. And as background, my clients were involved in submitting a recent zoning ordinance amendment to the town that was voted on regarding solar ordinances. And a member of the public made a comment about that, about the zoning ordinance amendment that was submitted, and she made reference to mean-spirited, Johnny-come-lately, yuppie NIMBYs who seemed hell-bent to turn our rural town into smelly suburbs. One of the planning board members commented on that, and I'll quote what the comment was, quote, remember, the Sculptos have an agenda, they are land developers. So the reason I bring that up is because the case law establishes when you're on a local board that's deciding these type of decisions, they call it quasi-judicial, but essentially what that means is you're acting like a judge. You got to do the same things that a judge would do. And what I would submit is that if you had a case in front of a judge, whatever the case is, and while you were before that judge, and the judge knew you were before them, that they posted a comment about you on Facebook that said you have an agenda, and that, in this case, they said they were land developers. They're not land developers. They've never been land developers. I would ask, if you had a case in front of a judge and somebody commented about you on Facebook when you were in front of that judge, you probably wouldn't feel that comfortable having the judge decide your case. You'd probably ask for the judge to hand it off to another judge. That was the request that we made in this case, and the member didn't recuse and voted on the case. And it's our argument that that was prejudicial procedural error. Because when you're acting as a judge, you can't comment on Facebook or in the public about the litigants that are in front of you. You know, to say they have an agenda, they're land developers, that calls into question their motives. And when you're giving a hearing, a quasi-judicial hearing, everybody that comes in front of you needs to feel that they're going to be getting, you know, equal and fair treatment, and that detracts from that. Now, I'm not saying anything personal about the member that said that, but I would say, and I would say it strongly, I would say in any case, I'd say it to a judge if a judge did it. And if you were my client, I know you want me to tell that judge, that wasn't right, you need to give this to another judge. And so that was the argument made in this case. The member didn't recuse. You know, he stated that they had evidence that they were land developers, which they're not. And, you know, he made reference to LLCs that show they were land developers. I don't know what they are, but there aren't any because they're not land developers. And, you know, they certainly don't have an agenda because of that. I know that in the brief submitted to this board, the developer's attorney stated that, well, they were just making a comment on a matter of public concern, but it wasn't just that. It was a comment about my clients when they were litigants before their court. And so our final argument is that there should be a remand so that the board member that stated that would have an opportunity to recuse because it was prejudicial procedural error not to.
Any questions on that, guys?
Yeah,
Okay.
were they they weren't parties to this, were they? They were objectors.
Well,
Would you make a distinction between somebody objecting to a proposal of somebody versus the parties that were actually involved?
No, I wouldn't make a distinction because they were direct abutters. And as direct abutters, they have the right to an appeal. You know, they can appeal to you, they can appeal to the court. They have an interest in this that the law recognizes. So, and not only that, we had appeared before the board previously at that time. So,
Well, I understand that, but at the time, they hadn't made an official appeal of a decision that hadn't been rendered yet, correct?
no, but they were immediate abutters that were objecting at the proceedings in front of the board that had the first shot at deciding. You know, in most cases, the planning board is the board that decides the case. You know, their decision, even though in this case we have a right of appeal, that hearing was the important hearing. So, and I think we're definitely litigants to that case because we're direct abutters.
Do you think that that board member had a specific bias against your client?
I think that that comment that was made, that they had an agenda, it's an indication that they were opposed to solar with an agenda because they were land developers. You know, that kind of shows they have some ulterior motive. You know, beyond that, I'm not going to say anything about the member beyond that. I'm just going to say, I don't think that statement was appropriate. And, you know, take it out to the precedent that's set, if it is appropriate. You know, if, let's say, because they're abutters rather than the applicant, or, you know, they said they have an agenda because they're land developers. Well, if you say that's okay, it's got to, you know, does that mean board members can comment on the people before them on Facebook to any degree? You know, I don't think that would be the case, just because they're abutters rather than the applicant. And I think that statement was a statement that should have been made.
In your closing paragraph for your brief, you had indicated that, in your opinion, it should be remanded so that the alternate, not a alternate, could be designated to sit in that member's place. Are you suggesting that it's only appropriate that it be remanded and heard by the current alternate?
So, I think you'd have to do one or two things. If you had somebody new, then you'd have to hear the whole case over again. At the time, there was one alternate that heard everything. So my suggestion would be, rather than have everything heard over again, remand it and just have the alternate that heard everything, just have that alternate vote.
Thank you.
Well, we'll just reserve the right to throw some questions. Maybe we'll recircle the wagons after we hear from Attorney Hogan.
Thank you.
Okay? You're welcome.
Members of the board, good evening. I am Margaret Hogan. I do represent the planning board as its solicitor since the beginning of this calendar year. Some of this case predated my assignment to the planning board. However, I am familiar with the prior travel. We're going to talk a little bit about that. I'm going to follow in the same order that Mr. Squires did as far as his arguments in my rebuttal, which is essentially the same way I've laid out my papers. I know you've read them. It will be a little repetitive in a sense, but since this is the oral argument, I do need to repeat some of those arguments here and to address some of the comments that were made by my brother. It's important to know that the board's jurisdiction here, and I know you know this, you just voted on another matter, that your role as a Board of Appeal is different than when you sit as the Zoning Board of Review. And essentially, there are three ways in which you could reverse the planning board if they had made an error of law, if they made an error in procedure, or the decision was just against the weight of the evidence. And my brother hasn't argued that third one, so we're not going to touch on that this evening. I'd like to start with the first argument, and that is that the planning board did not err as a matter of law when it found, and indeed it did find, that the PSES was a permitted use on the subject parcel, which is zoned commercial special. I'm not going to go into a long recitation about the ordinance from 1990 or what it means, because that's not my role. The role of the planning board was to determine whether or not the development was consistent with the zoning ordinance. And indeed, it found that under conclusion of law number 2. I've highlighted that for you at page 6 of my papers. And what it stated was the proposed development is consistent with the Hopkinton zoning ordinance and the town's long-held and relied upon interpretation of the July 1990 zone change, and it is the same use that the town has already approved for 2 prior applications for solar arrays on land that was part of the 1990 zone change. What has been overlooked by my brother in his argument is the conjunctive in that sentence, the word "and." There are 2 separate decisions that are being made in that conclusion of law. The first is that it's consistent with the Hopkinton zoning ordinance, as is a requirement of the board when moving on these applications. And the second part goes to the second legal argument that we get to, and that is the estoppel. So they made their findings on both elements, okay? Let's go back to the first finding. Why did the Hopkinton Planning Board come to that determination? What they did was they looked at the record that had been presented to them through argument by counsel. What you have to understand is that this matter had been pending before the planning board for quite some time before we actually got to the hearings on master plan. There was a pre-application that was argued, and in October of, let me look here, October of 2020, there was a pre-application, October 7th, I think it was, pre-application. And at that time, the abutters were represented by counsel, who made a lot of these arguments about whether this was a permitted use, it wasn't a permitted use, et cetera. That argument came on the heels of a series of legal opinions exchanged between the parties 6 months, 7 months earlier in March of 2020. And that's when the prior solicitors for the planning board had issued a very lengthy decision. Mr. Landry issued a very lengthy opinion, and it was either Mr. Squares or his partner that issued a very lengthy opinion as to whether or not this use was permitted by the zoning ordinance or it wasn't. All of those legal memoranda had been provided to the planning department and the planning board members. Then they had oral argument in October of 2020. Then it came forward in 2021 as the master plan application. And in those arguments, the abutters were arguing that we should make a decision. The board should be making a decision on whether or not this use is permitted, and because otherwise there's no point to even go forward with these hearings. So that's exactly what the board did in May of 2021. It made an initial determination that, look, we're finding that this use may go forward. We do believe we're bound by a estoppel, and we'll get into that next. But we're going to go forward, and we're going to hear this application. That didn't stop the discussion or the argument about whether this is a permitted use. It hasn't stopped today. We're still arguing over it. So the board did not ignore their argument. It listened to it, and it made a determination ultimately under conclusion of law number 2 that it determined that this was a permitted use. Now, why did they come to that determination? So that brings us to the history of what happened. And we heard discussion from my brother about zoning officials can't issue binding determinations on zoning certificates. But zoning officials are charged under law with, in fact, issuing zoning certificates. Now, whether or not the courts decide that we should rely on them or not, that's certainly an opinion, and that person has the duty and the responsibility to issue that opinion when asked by a petitioner or member of the public. In addition to which, when that zoning official made his determination and her determination, they reached out and relied upon their legal counsel, which is exactly what you would expect a town employee to do when asked a question within the scope of their occupation. What do I do with this? I'm not sure about this. It's a legal question. I'm going to seek out an opinion from our solicitor. So that's what they did. They didn't do anything wrong. And the suggestion in the filed papers that the cases are controlling that where we had Pezza with the concrete plant and Martel over in Richmond, that those cases are controlling, is really insulting to your town employees. In those cases, in the Pezza case, what happened was the zoning official in Cranston, Johnston, unlawfully issued, and it's implied that it was political in the decision, the court says that, after an election was lost, issued a permit for this concrete plant or asphalt plant. And after the election, when apparently he was removed from his position and replaced, the next building official came in and revoked that permit. And this guy cried foul, saying, hey, wait a minute, I got a building permit, I should be able to build. Well, that building official had no authority to issue the building permit to begin with. It was illegally issued. And so when the new building official came in and revoked it, that was appropriate. And to suggest that the folks here did something unlawful or untoward is really disturbing. The Richmond case was the case of Martel with the adult entertainment business. He came in and the guy got a building permit, and the building official had erred. he made a mistake by giving the guy a building permit without sending him to development plan review. Again, that was corrected, and this guy complained, the applicant complained, and the court said, no, this is a situation where the building official erred, and so it was beyond the scope of his duties to do this, and so, no, you don't get to rely on that. That is not the situation that is occurring here. Not at all. You have building officials who, in the course of their duties and responsibilities, are trying to make an honest determination as to whether or not this use code is allowed in the zoning ordinance. If they're not allowed to make that determination, as suggested by my brother, how does the building official ever issue a building permit? Of course they have to interpret the ordinance and look to see whether something's appropriate. And so when a board or an applicant comes in and says, can I do this, can I not do this, that's going to be the starting point. Now, whether or not somebody should ultimately rely on that down the line, I guess you can argue about that. But the planning board is relying upon the expertise of a building official and the expertise of their solicitors in interpreting these matters and relying upon those decisions. And there's nothing wrong with that. It's done all the time as it should be. In the situation with these opinions, the first one occurred in 2011, and then after 2011, somewhere along the line, in the late 20-teens, I believe, one of the parcels that was part of the original Brayburn zone change came before the planning board and got an approval for a solar project and began construction of that solar project. And a second one came in, and in fact, in October, I think it's the October 2020 agenda, it just so happens that immediately following the argument over whether or not this was a permitted use on this particular site, the second solar project was before the planning board on the same agenda. So I really made an argument that, okay, well, these zoning certificates are not, they're not public knowledge. We don't know about those things, so we can't appeal them, and we can't challenge them, and the only time that we can talk about it is when we get to an application. Well, okay, but if you're in a butter to a project, don't you know that there's a solar project being built next to your property? Doesn't that put you on notice that, I don't know, solar is a permitted use here? And then there's a second one. This is the third solar project that the town has heard for land that was originally part of the Brayburn application. And that's a very important point, and I don't think that this board should lose sight of that. So, the board's determination, the planning board's determination, that it was consistent with the zoning ordinance is wholly appropriate because they relied upon expert opinion. You had dueling opinions, dueling arguments. They selected one, they went with that, they made a determination under conclusion of law that it was consistent with the Hopkinton zoning ordinance. Simple as that. They didn't fail to make that determination. Second argument, do you want to ask questions before I move on?
Yeah, let's just, let me ask the board, you guys want to have any questions on that? Good, Joe? Good, David? All right.
But that was two separate town attorneys that agreed to get to that point, correct?
That's correct.
Two separate projects, two separate town attorneys that agreed,
Correct.
or listed opinions. That
Yes,
was-
they provided opinions to the planning board on this, no, pardon me. The first one, Mr. Romano wasn't providing an opinion to the planning board per se. He was applying, he provided that opinion to Mr. Ward when he was issuing his zoning certificate. So Mr. Ward wasn't quite sure, I guess, or I'm not sure, but anyway, he relied upon an opinion from Mr. Romano.
Either way, two different town attorneys, same opinion.
That's correct. And those opinions are also consistent with what Mr. Landry had presented in March of 2020 to the planning board. And so the three attorneys had all circulated opinions amongst themselves, with differing points of view. So we have three written opinions from attorneys that my planning board is looking at and relying upon when coming to a determination. It's wholly appropriate for them to rely on professional opinions when coming to a determination. Otherwise, why do you have a solicitor?
What was the primary reasoning to overcome council's argument that that limitation that the council initially put on the zoning change? What was the preliminary or the primary driving factor that got over that?
I'm not quite sure I'm understanding.
Well, he's arguing that it's limited. I'm not really concerned if there were 2 projects, 3 projects, or 5 projects, because there still could have been a mistake made. So what he's arguing is that when the council made the zoning change, instead of going straight commercial, and went to commercial special and put specific limitations on that approval, how did the planning board get past that to say that a solar array was allowable under the circumstances?
I believe they relied on council's written opinions. That's what they did. They didn't get into large, long discussions about this comma or that word or whatever. They relied upon the opinions that they were provided by their legal counsel,
And what is that opinion?
that this is a permitted use.
And they base that on what?
The legal opinions that were rendered by,
I think they're trying to get out what was in the legal opinions
That's where I'm at.
pushed them over the edge.
oh my goodness, they're pages long, and I'm not prepared to argue other solicitors' legal opinions. They're in your record. I'm happy to supply them if you don't have them, but they're in the record.
But you gave guidance to this planning board in this hearing, correct?
Yes, I did.
Okay.
Yes.
What, can you sum up your opinion?
I advised them that they had the right to rely on those opinions. They did not wish to get into additional discussions about this. There had been enough by the time I reached representation of the planning board. They had enough in the record about this for their purposes.
Well, the crux of this, the first argument to me is, what did the council approve? Did they approve a specific use based on 4 or 5 specific uses, or did they make it commercial with extra uses? Right? And that should be in the minutes and the transcripts of that meeting. And the legal opinion after the fact, to me, I don't see the relevance of it. Those transcripts have what the council meant, what they approved when they changed that zone.
But if 2 town attorneys at 2 separate times read all of what you're discussing and then turned around and said they believe it's still a permitted use, that is relevant.
Those are legal opinions. And
Right, based on-
the planning board hung a hat on somebody's legal opinion, right?
2 separate,
That's fine, it doesn't matter if it's 1 or 2, but yes. But again, what did the council approve?
That's precisely what I'm getting hung up on. I just don't understand when they make reference to that by incorporation, because I just don't see it. In the minutes, you have somebody taking notes. It's not a transcript from that council meeting that they're relying on. Those are handwritten notes taken by the clerk. How do we know, what's not there?
I mean, I'm not an attorney, but to me, that's where, if there's an error of law for attorneys to confuse what the council did, what did the council specifically say? That would tell us if there was an error in their opinions and an error in what the planning board did, because how was it specifically approved?
so basically you're saying without a time machine, how do we know what they were thinking?
That's not what I'm saying.
It's in the transcript of the minutes, I mean, we have to look
But
at that.
Danny's saying it's minutes and not a transcript, so it's not word for word or...
They're the minutes. It's just not taken with the level and level of precision that she's going to memorialize this particular meeting with.
So what are you trying to say?
I was just trying to clarify the argument. I understand the argument, I get it, but I want to understand both positions. I think he made his point very clear. I'm just trying to get the same thing from council to the planning board.
All you can rely on is,
Confused me a little bit, that's all right.
all you can
You
rely
have to
on,
rely on the recorded, they're not the minutes of the council, but the written notes, and they are recorded in the land evidence records as legal documents, no? At the end of the day, that's what we have.
well, yeah, you can't read into them. I mean, it's not, you can't add different things and read into anything else other than what's written there. It's the same point I was just gonna make. I mean, however they documented, that's what the commercial special means. If there was representation that we only want these 4 or 5 specific things and that's it, and that's where the tail ended, that's fine. If there was more to that within the minutes that gave us an inclination that it was commercial with additional uses as opposed to just these host of uses.
Just these what?
This host or group of uses. You guys follow how I'm looking at that? I don't know the answer yet, but that's the way I see it, is what is that? Because after that, there's errors down the line if they only approved a group, or if it was changed solely to commercial with additional uses, because some of those uses are not allowed in the commercial zone today. A golf course is not allowed. Residential housing is not allowed. So did they allow commercial with extras so that they could get those extra uses in for that project and only that project? What did they mean? It's in the record. I think after that, the rest of it is kind of irrelevant.
Well, I think, frankly, just to
Yeah.
sort of square the corners again, you know, your review is confined to the record that you have,
Right.
so.
On the issue of the estoppel, the doctrine of estoppel. So there are instances in which estoppel has in fact been found to, in a municipal setting, to prevent a municipality from harming a property owner or an applicant. And I cite for you at page 11 in our papers, the town of Gloucester versus Olivos Home Court, Inc., 300A Second 465, a 1973 case. So there, the town of Gloucester issued a determination that Olivos' use of his property was illegal, that it was in excess of 30 units at the mobile home park. And the court reversed the town's decision on that and noted that, look, you town granted licenses to this entity year after year after year from 1965 to 1969, and that Olivo had expended a substantial amount of money in reliance on those licenses. So the town didn't get to, after the fact, say, this is a illegal use, and the town was prohibited from doing so. So the board was very sensitive and aware to the fact that this had been a long-standing determination, this use code had been a long-standing determination by the town from 2011 that additional commercial uses were allowed for these properties. In addition, the board was, now that no one ever even raised the issues when no one challenged the issue when the other 2 solar projects had come forward, and they found that they were consistent and they went forward. And so we have 2 legal opinions. We have 2 approved projects. And then this particular applicant went to the zoning official in 2019 and inquired, is this a permitted use? Again, knowing that other things one had been approved and one was in the hopper, this was I would term it a belts and suspenders inquiry, and the building official said yes, and then the applicant closed on the property in reliance on the town's position, where they issued permits for solar on this property, and closed on the property and expended substantial sums of money. Mr. Landry testified to us at the planning board as the dollar amount. I'm sure he'll talk about that. And so the board felt that that was another reason why, under this particular set of circumstances, that this use was appropriate or not appropriate, was allowed, because it was too late for the town to say, this is not an allowed use. They've already allowed it twice on the same parcel of land that was part of the Grayburn application. And how does a planning board say no to the third applicant when they've approved two others without resulting in a substantial injury to the town? That was weighing very heavily on their minds. I won't get to the other cases that I support, that I cite in the pages. You can review those. And finally, the third item about the prejudicial procedural error alleged, so-called, for Mr. Perowitz's participation in the vote. This evening, at oral argument, Mr. Squires would not agree upon questioning that there was bias. That's what you need in order for a court to remove somebody from a position in a decision. In this case, I've highlighted for you that the screenshot, if you will, that was attached to the appellate papers was not part of the underlying record, was not submitted to the planning board for its consideration. It was, I received a copy of the allegation by email. There was nothing filed with planning, there was nothing filed with the planning board, and it's not part of the record. So it's really not any evidence in the case to begin with. But to the extent that you consider it to be evidence, we'll review that. There was a phrase there, name calling, and Mr. Perowitz allegedly responded to that by saying they're land developers. Mr. Squires takes that statement and goes on to describe it to our board as false and defamatory. And he asserted to the board at the hearing that it's unequivocally false. And that Mr. Perowitz doubled down on his accusations at the hearing at which he had asked him to recuse. Counsel did not present Mr. Skulko or Mrs. Skulko for any testimony. They didn't, I don't know if they appeared in any of the hearings at all, or whether they looked at the proceedings by Zoom or didn't participate at all. But they never testified before the board. So all of Mr. Squires' characterizations, representations, and argument about this phrase that Mr. Perowitz allegedly typed on Facebook is all just hearsay. And you really shouldn't even be bothered with it. Additionally, he's asked you to send it, to reverse the board on that basis. And send the matter back to the board with Mr. Perowitz recused. We don't have any authority to remove a board member from another board. And he cites no case law, statute, regulation, or authority to suggest that you do have that kind of authority. You as board members can't tell another one, you got accused. I know that you dated his brother-in-law, or whatever your argument is, that somebody's gonna be biased, you gotta get off this board. You can't do that. The individual member has to determine whether he or she has a conflict of interest, whether they can hear this application fairly, and treat the applicant with the appropriate requirements. Mr. Prowitz, when asked to recuse, said, look, I've done my research. I looked up on the Secretary of State's office. I saw that the Schuylkills have LLCs. Apparently, in Mr. Prowitz's mind, that means that these holding companies are development companies. Now, whether you and I would reach that conclusion, that's not relevant. But what he also said, which was ignored by my brother this evening, is that he said, I voted for and I voted against these applications. I can treat this fairly and impartially. Excuse me. I do not believe that I've done anything wrong, and if I did recuse myself as being requested, I'd be admitting to doing something that I didn't do. That's a pretty honest assessment, I believe, of where his abilities lay. He said, look, I've supported them and I've been against them. It's got nothing to do with anything. And he also said that the Schuylkills did everything right. Good for them. I don't have anything against them. So to suggest that a phrase on Facebook evinces sufficient bias to remove someone from a hearing is just not there. And Mr. Squires even stated this evening, he wouldn't characterize the statement as biased. He did say in his papers that there were a couple of cases that you should look at on this, and I went through them for you and gave you the actual facts of what happened in the cases, as opposed to just a legal holding line, which might say this or that. In the Barbara Realty Company versus Zoning Board of Review, the zoning board member there, and this was a corroborated statement, said to a concerned abutter about a pending application, what difference does it make? We're going to shove it down your throats anyway. And the abutter testified at the hearing and said, well, you would object to it if you lived there. And the board member replied, I don't live there and I don't care. I don't live there and I don't care. We're going to shove it down your throats. Not the same thing as saying somebody has an agenda and they're landowners. Very, very different flavors of statements. Also in the Champlin Realty versus Tacoyan case, the never-ending Champlin Realty battle that's been going on for the better part of 20 years here on Rhode Island. The trial justice in that case noted that in addition to ex parte contacts, of Mr. Tacoyan, who was the chair of CRMC at the time, with subcommittee members having improper conversations like you're not supposed to have them. He wasn't supposed to have them. He also threatened a member that he wouldn't be reappointed to his seat on the CRMC if he didn't support a particular plan. And the judge pointed to the fact that his communications with reporters, in addition to these other things, evidenced a bias and necessitated his disqualification. Nothing like the facts that you're presented with here. Mr. Prowitz made it very clear that he took his responsibilities seriously, that he's voted for and against solar applications. He did not feel it was appropriate to recuse, and he did not do so. This was not prejudicial procedural error by the board board had no ability to do anything about Mr. Prowitz's determination, and you, as a board, don't have any authority to, even if you were to find that there was some kind of bias here, don't have the authority to remove a board member. So for those reasons, I would suggest to you that this appeal should be denied and dismissed, and the Hopkinton Planning Board's decision should be upheld. I'm happy to take any question.
Am I able to ask questions?
Oh, yeah.
No?
Yes.
I just wanted a clarification. So, I'm a little bit uncomfortable with the argument that you're saying there's no bias, because I don't think it's hard for you to determine what's insulting to someone or how someone feels by words that other people are saying about them, right? So, it's one thing if there's no legal action to ask Mr. Prowitz to recuse, but I'm just uncomfortable with you saying that this, that request be denied because there was no bias when I think, for instance, I'm assuming you're familiar with the term, they have an agenda. That term inherently has negative connotations to it. I mean, you could say, no, it doesn't, or you're not interpreting that way, but I think generally, as a public, as society, we know when someone says they have an agenda, there's negative connotations. And so I just think it's unfair to make a claim that there was no personal implications for the people here, I'm sorry, I'm trying to make blank in the skull. I'm okay with you saying that you could not ask Mr. Prowitz to recuse himself. I'm aware that that also has to be a personal decision. I'm just uncomfortable with the other half of the first half of your argument. That's all I'd like to say.
Okay, that's fair enough, but there's a legal, it has to rise to a level of legal bias in order for someone to be bounced, if you will, from hearing a case. And the cases, we didn't get into lots of them here, but there's lots and lots of them. These are good examples of them. I could have cited 20 more of how such a statement does not rise to the level of bias as to create reversible error.
If you were to make the statement that the Scocos, say they were developers, how does that hurt? If they were developers, then they'd be out trying to do the same thing. So what I'm getting at is, how is that prejudicial at all?
I don't know. That's not my argument.
No,
If
he said, or anybody said, well, they're just anti-everything, that might be a little different. Maybe not, it's still an opinion, but.
I didn't mean to go down that route. All I was pointing out, I think you've made the argument that regardless of what they said, you can't ask Mr. Prowitz to recuse, which means then it wasn't then the planning board did not exceed their authority by having him not recuse, correct?
Right, so just so that we're clear, Mr. Squires did ask Mr. Prowitz at the hearing to recuse. And he responded that, here's the reason why I don't believe I need to recuse. Because I went to the Secretary of State's office, I found that there are LLCs by these abutters, and he gave all his rationale, we've set it forth in the papers here. So, and he also said, look, I have voted for these things, I've voted against these things. I can act fairly and impartially.
But the main point is, it doesn't even matter. He didn't have to give that explanation because the only person that could recuse would be him, would be his decision. He chose not to. Whether we think that's right or wrong is irrelevant here, I think, because it doesn't affect it doesn't determine if the planning board erred or not. Am I correct?
So, well, exactly, because the planning board couldn't turn to Mr. Prowitz and say, you gotta go, we're putting somebody else in your seat. So the planning board did not err. He's a sitting member. He said, I don't have a reason to recuse, I'm staying, that's the end of it. That is not an error of law or a procedural error by the planning board. It simply isn't.
Some members of the public would like to speak, but I want to let you finish.
I'm finished.
No, you don't have to yet, but typically, we would let council come back and rebut a few things now.
Well, they might if the public.
I think, at some point after the public comment, we may want to take a break and have Mr. Landry come back after the break, and then have some rebuttal by Mr. Squares. I don't know if that's.
You wouldn't be finishing oral argument by council first?
Typically, that's what we do.
I would think you would let Mr. Landry go after me and then take the public.
Typically, we do the public at the end. I just wanted to make you guys aware of that, because I want council to go back and forth. We can recircle, so if you make some notes on points you want to take up, I don't want to interrupt them, because if not, we just head down a rabbit hole of confusion. So
Can we have a couple questions? Back to the two parcels that were part of this break burn, I think the 3 parcels total?
I think it's 4.
That are for commercial special. You said that 2 have already been approved as solar projects, or at least one was approved, one's pending?
Yeah, they're both approved.
Both approved?
Yes.
Did this issue about the commercial special come up prior to or in conjunction with the 2 solar projects when they were proposed?
Not to my knowledge.
Not to your knowledge? And you stated that the Skolkos would have been notified. Are they in the radius zone, or were they notified by a newspaper, public notice in that respect?
You know, both of those predate my participation, but I would assume there would be a notice requirement, but I can't make that representation 100% on the record this evening, but that information could certainly be determined. But I would assume that would be the case, since they're, unless the parcels, these other 2 parcels are far enough away,
Sure, 500 foot.
outside the radius. It could be that this parcel is the one that's closest. I just don't know.
Okay, wouldn't DPR require that they get noticed?
I think it's 500 foot, right? By certified mail, and then it'll be a newspaper notification. I think it's 5 for planning, 200 for zoning.
Yeah, and again, I don't know the layout of where properties are, so they might be outside of the notification range.
I simply don't know.
Right.
Just curious.
Never her. It's certainly not fit in. And it's a problem.
No, I agree. So, board member Barudi and I are having a discussion. Your memorandum has not been given to us. Right? We've had an issue with getting documentation from the planning board about who needs to give us what when. It came down at the 19th hour, so we have not received your memorandum. So you're touching on a lot of things we have not seen yet.
I am so sorry, I had no idea. It was provided to your clerk.
I've been involved in the chain of emails on that. It's not my clerk's fault that we have not received it. There's been a lot of discussion with council back and forth, from planning to my clerk, about whose authority it is to print things and not print things.
No, but this particular memorandum went to your clerk directly from me.
That one, if that's the one that you sent to me, if that's the one that you sent, it is in your packet.
That's in the,
Yes.
where is it in our packet? Maybe I've overlooked it.
It's in, like, your envelope.
It's in, okay, I'm sorry.
Yeah.
I'm sorry.
Because I separated them between zoning board and board of appeals.
So again, but it still came in, when did this come in? We probably should have picked this up last week.
Yeah, it was sometime
Okay,
last.
all right, so this is an aside from the other issues we have.
Yes, I'm aware of that other issue.
Okay, this was in our packet, so the error is on me on that comment. But the other, you're aware of the other issues.
I am aware of that, yes.
That's not our clerk's issue. She's not the one that's supposed to make copies. She's a conduit between us, just like in this, where, this did come to us from her. But those documents from planning, or whoever, from an appellant, whoever, they need to be given to her, she will provide them to us. It's not her duty to run these around to printers and different things, and it's been quite interesting to watch the travel on that, and it's a little upsetting that they're putting the burden on my clerk again. She's supposed to just hand us documents presented, whether it's the town or a private citizen or a developer, whoever it is, it's not her duty.
I concur.
Okay.
So what you're saying is the planning board should have been providing the documents to us and they haven't been.
No, so they gave us an electronic copy, and that was all. As you well know, for the time I've been here, we've never received an electronic copy. We do not have technology before us, nor do I necessarily want it, where we can now sit through a meeting with an electronic copy and shuffle through all these documents. It just doesn't work for this board.
I think the problem is that, while you did just decide an appeal this evening, there's not been a large amount of these matters, and there's confusion as to what the role, the other solicitor and I, we can work that out so that there's a memorandum that explains what everybody's responsible is.
I agree, and I've had that discussion privately with a few people. Is how many times have we been a Board of Appeals? 3 in the last 15 to 20 years. So I don't disagree, we don't do it that often. So when obviously the town's part of it, I don't think any of us really know how to handle it.
I think you'll be doing more of them, so,
Well, I hope that
so
we
we'll
can-
get it worked out before the others come in.
Yes, no, and I hope so, because, again, I'm gonna stick up for my clerk. It's not her duty to be doing another town officials or town employees' job. This is an extra job that she does for this board. It has nothing to do with her assistant tax assessor position. She's not just another town employee. She's working for our board. I wouldn't put that on somebody else to turn around and say, well, no, you're gonna do this.
Yeah,
That's-
I don't disagree one.
And I think it's the confusion. I don't think there's any ill intent by any means.
No,
I just think it's just a confusion.
that's exactly what it is.
All right, that's, sorry.
We'll get straightened out, though.
Yeah, okay, all right, we'll get back on track. So I think, Attorney, we have another.
You guys want to give the steno a break?
Yeah, I think so.
Okay, all right, let's take a 5, good. All right, can I take a motion for 5-minute recess? Second. All in favor? Aye. Aye. Okay. Good job. Get that on record.
Because Bill's gonna wanna go. That's the,
We're running.
you're gonna have to decision.
Oh, no, but even in the public, it's not gonna be. Probably not. Well, plus we're running out of time.
Yeah. Yeah, that's what you mean. That's perfect. I mean, you guys can move to, if it's not gonna be super long time, you guys can move to continue past 10, but.
Well, we're not gonna finish anyway, so. It's hard. I don't disagree. I should just, we all should pick it up. That's not, that was on me.
About 200 sheets of paper.
Yeah, no.
I was looking at the other one, I couldn't find it for a
This came in last week, so I didn't know what Dan was asking me where this was. I thought it was tied up, because they have 3,000 pages. This is the emails I have. It's crazy. No, there's a lot of stuff here anyway, it's easy to overlook it.
Yeah.
It's not her error.
I only can just pick up the packets this week.
I don't know.
I usually do it first, but I race home to get the kids up first.
Oh, Big Daddy.
How's the dozer working out over there, Joe? That cat D3 there?
Yeah, my neighbors think they're back, trying to build my stone wall. Well, I have no idea what to do with this tool. I'm not a landscaper. I have no vision for it. I've got such a great understanding of the property.
Oh, yeah. You doing an animal or you doing the dry stone wall?
Just a dry stone wall,
Yeah.
kind of wasn't painting the wall.
I think on a.
I have no idea what to do with that. I'm almost there right now, landscaper. I don't know anything.
Do you want that?
So it's not like something I look at every day and it's really trying to.
14 years already.
I think even if you get, look at, she does a great job. She's a landscaper, you know, it's somebody that
Yeah.
does that kind of work.
They're all busy. Busy.
Give this guy a call, friend of mine, Vinnie Cardo's list.
Vinnie Cardo's
list. No, he's a landscaper, so but he's worth talking to because he's a real decent guy. And I don't know, he's got a bunch of guys that worth talking about. He does, and just for clarification, he does work down in Watchtown in the fancy area, so just put a heads up, but he's a real down-to-earth guy, you know.
I can do Zoolander code.
I think it's called Four Seasons, his company.
This is the wrong way.
Okay.
Couple too many wrenches.
Thanks for taking that.
Well, it's a lot cooler down here than it is sitting up there. It gets very warm up there, I discovered.
Yeah, I was very warm right here.
I came out last night.
Sorry, I hit that thing in the middle of testing all over.
932.
It's not like a patent stuff.
9829.
9829.
Beverly Hills.
Vinnie Cardo was a real good guy. He was a wrestler, you know, Vinnie.
Oh, yes, I do, yeah, that's all.
He was a landscape business, but he might be, Joe's trying to do some wall work and stuff. He's not a landscape architect, but I bet he does.
932, 9829? I'm sure I got that right.
Nine 9829, yep, 932, 9829, okay.
Yeah, give him a call.
You just get him out there, come take a look at it, say, what do you think?
Yeah, because I can build wood, but I don't know stone.
So I know one of these lines. We got 15 minutes. We'll probably have.
Let me see how much time it needs. Why don't you ask him?
Wait, I mean, do you guys want to extend and give them a few minutes? I don't think they're gonna go on. I mean, I don't know how much. Don't you want to?
Landon, Bill. How long do you think you're gonna have for your presentation, Mr. Landry?
I think it's gonna be about 15, 20 minutes.
Okay.
I'll try to pare it.
Yeah, no, that's okay, we normally have 10 o'clock, which.
I don't want to rush it either. I mean, I want to give you as much time as you need, because I know some of the public would like to speak too, and, you know, we're looking at 10, 15 minutes.
I think we have to have the motion to extend.
Yeah, well, that's what I'm getting extended. I mean, we've gone half an hour. And not that I want to, but I mean, I don't want, if we need 10 to get it in and give them a few minutes to speak too, so we can try and get everything together, but I know, Attorney Swerz and Attorney Hogan would probably like to come back around and rebut a little bit.
Yeah, I hope not to be limited to 10 minutes.
No, I don't know, that's why I'm saying is I don't want to, rather than get you on a roll and then cut you short and then come back next week, maybe I just give them a minute to speak, get them to, and then, get them to get their points on the record, and then we come back and start fresh with you next go around.
I don't have any problem with that. That's fine.
'Cause, I mean, I hate chopping the testimony in half, because trying to get us all back on the wagon to your thought process a month from now is a little, nothing we can't do. As long as I pay attention and we actually open the envelope.
However you want to do it, this may be a while here, I probably, if I followed all my notes, I probably would have a good half hour to present, because there's a lot of issues.
Yeah, oh yeah.
I got the scores was longer than that, Maggie was probably a half hour, there were questions, so
That's why I don't want to rush it.
yeah, this is, Maggie represents the town, it's very important in terms of the planning board. This is my client, I presented this project for the last year.
That's why I want to give you the time due for it, so, I mean, my own view, I'll ask the guys too when they come back, but my own view is to let's just move you to next month, take the time you need, when we read through.
received my brief? It was filed the same day as Maggie's, October 12th.
It's probably in this.
So that,
You see it? Yeah, it's here. Yeah, sorry, that's my error. I thought it was tied up in the stuff.
I will tell you that both Maggie and I filed on the same day, October 12th, day after Columbus Day, and we asked that the paper copies you needed, you would make them, they were out, so I apologize. I think Maggie asked that, I asked the same question. I normally would have had multiple copies printed and delivered. I did not do that because that's not, didn't appear that that was required. But if I had to do it again now, hearing what I'm hearing, I would have sent packages of paper.
We need 7 to 8 copies, because we got 5 members, we got an alternate, then usually our attorney, we need it as well, and we need one for the recs. Okay, we got yours, but it was tied up into the stuff I didn't see, because there's so much stuff between this one and the last one. I mean, I walked in with stuff, so I overlooked it. That's my error. Can you get them, let's get, well, we only got a few minutes left. I was coming back, trying to get my mind and stuff. It's not with juice.
I'd rather get I miss a lot of I was going to
It must have been pretty slow during the pandemic, though. She's tired. She's the resident.
Can I take a motion to re-adjourn?
So, second.
All in favor? Aye. Reconvene. Reconvene. We knew what you meant, same but totally different. Okay, looking at the time that we're at right now, and we've got about 10 minutes. I don't think that the property owner's attorney has enough time to get his presentation in. So if you guys would all agree, I would like to move him to next month's meeting so that he gets all the time that he needs. And then we'll have the other attorneys come back and rebut if needed. Are you guys fine with that?
I would prefer to motion to extend to 10:30 if Attorney Landry feels he can get his presentation in 40 minutes. I think we should leave it up. I would rather defer to him.
Well, it depends on how many questions you guys have as well.
We can save the questions for next go round. It's up to you if you guys think we can get it in. I know we've got some members of the public that have some comment too. I'm fine either way, that's up to you guys.
Well, we're definitely not going to finish anyway, so
No.
I'd go with Dan's, I mean,
at least we'll get Mr. Landry through.
he's come down here, I mean, at least.
If he feels comfortable that 40 minutes is enough time, if there's any question, let him continue.
Yeah, to be honest with you, I don't know if it's gonna, my brief was twice the length of Maggie's brief and Peter's brief. It was more than the length of their briefs combined. I got into issues that they didn't. A lot of those issues are responsive to questions that the board has tonight. I was prepared to read the sections my outline has, what the attorney said and why. And it takes a while to get that out. I want to say a half hour. If I was going straight and talking fast and trying to get everything in, that could probably happen, but that hasn't happened in either of the previous two attorneys' experiences, with much less. Peter's brief was obviously very good, as it always is, with about 6 or 7 pages, and I just got a lot more to say, and I honestly would feel at 10 o'clock at night constrained in trying to, particularly where you may not all even have had a chance to read the briefs yet. That might oral argument was premised in the first place on everyone being familiar with what's in the brief, and trying not to be repetitive of that. So I think it would be more helpful if I had, if I wasn't on a clock here. I don't know if it would be a half hour, 40 minutes, 50 minutes. I honestly don't know. And it's, it's 10 o'clock. I don't know how everybody else is thinking at 10 o'clock at night compared to how they're thinking at 7:30, but I can tell you how it works for me, so.
Well,
I would
we left it up to
prefer-
you, so if you're comfortable, we'll put you off till next month.
Yeah, I'm fine with that.
Okay.
Okay, that's fine. I know there's a couple members of the public that want to speak. I don't know if you guys are going to be
5 minutes.
long-winded, 5 minutes. Again, so members of the public, I think I made this clear to Mr. Morrow in the past on different hearings. Where we're sitting as the Board of Appeal, we can't take any new testimony. We can only speak on what's presented. So we've got to try to keep, so if I interrupt you, or if our solicitor interrupts you to try to keep you on target, because we all start to wander, we do it up here, and if we get off topic, we got to rein it back in and stay right to the points. So,
Just to put it another way, anything that you say that's outside of what's already in the record, we can't consider as part of the board's determination.
okay.
Just a clarifying
Oh.
question.
Nope, stand up, you gotta, actually, come up to the podium, please. We're gonna put you on the spot. I'm swearing. Yep, we're gonna swear you in first, so.
I'm not testifying, I just had a clarifying question about what's available to the public. I don't need to put any new testimony or any testimony period on the record.
As far as, what do you mean, what's available?
So the.
Can I just get her name?
Yeah, no, please.
Amanda Blau, B-L-A-U. The solicitor referenced what's already in the record. And I'm wondering if the materials you have, the materials that have been referenced by council, are available to the public.
They're available for inspection at Town Hall
Okay,
during business hours.
okay.
There's a lot of it.
Briefs and prior meeting minutes and solicitor opinions.
Yes.
I don't need anything that's.
There's a lot of it, so much so that I was confused that I didn't think I had things that I had that were given to me a week ago. But then there's other things that we didn't hit because there's just so much of it that we got an electronic file, which, anyway.
Okay, so there's references made to prior meeting minutes, solicitors, public, like letters, opinions. Those are available for public viewing.
Yes.
And the planning board record is available on the minutes and public portal, I believe through the town's website as well as through the town's website.
Just minutes and agendas, or would that include like
And materials that were
supplemental?
submitted as part of the meetings.
One more time, Mr. Baker?
Materials that were submitted as part of the meetings.
Yeah.
If you go to Hopkinton meetings and agendas, and you go to the planning board under every month, it lists the documents that they're reviewing that month, in addition to what might have come prior, but they're all there because they posted them during COVID. So they're
Right,
for everybody.
but would council's briefing be, they wouldn't, those would be, just come to the
That'll be at
town.
the town hall. No, I'm sorry, go ahead.
Oh, you mean the briefs in this case?
Yes.
I think, no, I don't think, they're not on the planning boards.
They would just, as the attorney said, be available for inspection. Yeah.
Right. Yeah,
Okay, thank you.
okay.
You're gonna make me look bad, because I have a...
Well, I'll come back next month and with a list of questions.
Joe Moreau, Old Depot Road. Just a couple of points that I wanted to mention. This property, as you stated, was rezoned in 1990. I've been involved in these projects since June of 2018. I've attended every planning board meeting, listened to most of these zoning board hearings, Conservation Commission, so forth, just to learn more about our town. I've been heavily involved in this project from it started as a medical facility and so forth. But with the rezone in 1990, the clients for the attorney representing the Stelcos, they purchased their property in 1995. So it wasn't like they purchased the property and then it was rezoned after. So I'm assuming they did their due diligence to review this and realize that the property was rezoned in 1990.
I did hear Al Diorio, I listened to, as I said, to these meetings, I had heard Al Diorio say, and I respect Al, as much as I want to vote no on this project, I cannot do that. And the reason that he stated was that this parcel was previously approved for 2 solar projects, so he could not vote no. As I said, when I did the research, I found that for Thomas P. Skolko and Cynthia Skolko, there are 4 LLCs.
I think we're getting a little bit outside of the
Okay,
record.
all right. Can I discuss this point that was brought up with Ron Perlowitz about his comments being land developers?
Was it actually part of the record, because that was brought up?
It was part of the record. It's
Is it in the transcripts?
It's in the minutes of the meeting of the planning board. Basically, all I wanted to say is that's his opinion. That was his opinion as land.
Oh, no? Oh, we don't know?
There are no LLC filings in the record as far as I could tell.
No.
No, Ron's comments.
Ron's comment.
Yeah.
Did that actually come up in a meeting?
Those comments are in the record.
Okay.
I'm sorry, for the attorney, are you saying there aren't any records of any conversation about LLC?
That's not what I said, no.
I clearly. Oh, on the record. Well, I clearly mentioned it and discussed these LLCs at planning board meetings, so that would be part of the record. I was here at the podium, stated my name just like I did tonight, and presented it as part of the record. It's not on the transcript, but it should be minutes of the meeting. I clearly discussed that several times about the LLC.
Was that for Mr. Prelowitz's comment on Facebook or after?
It may have been prior to and after. I'm not 100% sure on that. But I discussed it a couple of different times. I'm sure Mr. Square probably remembers it, but I did bring this up at planning board meetings.
Okay.
And I certainly will go back to the minutes of the meeting and find that information for you.
Well, you understand why I'm curious, because if you said it before, then if Mr. Prelowitz said it after, it's part of the record.
My point is, if it's in the record, it's in the record.
Yeah, right, I don't know.
Right. Should be part of the minutes.
Okay.
But that was basically it. Thank you for your time. I appreciate it.
Okay. All right, gentlemen, anything further for tonight? We're at 10 o'clock. Ms. Hogan.
So, Mr. Chairman, members of the board, I think your next regular meeting is November 18th.
Correct.
So both Mr. Squires and I have conflicts for other boards that evening. And the suggestion was made, is it possible to, for us to select another night? Mr. Landry would be good with that as well. Or we have to continue to another month, but.
It's going to be at the
That's
pleasure.
just going to be difficult, because normally it's difficult for us to schedule before. It's easier for us to schedule after, like the week after, and then the week after is Thanksgiving.
Right.
Yeah, I mean, you're hitting, Thanksgiving's on the 25th.
Yeah.
So, I mean, if you push from that month, and then we go into December.
Usually the beginning of the month is pretty bad.
There's no space that would put you into January.
Or our regular meeting.
Well, I saw, yeah, but there's no Thursday whatsoever, unless we switch to another night.
I think the 16th would be December.
No, all right, no, I'm sorry, yes, the 16th is our regular, we could do that, I'm sorry. There's a lot of stuff on this calendar.
The 16th of what?
December. Just the,
How about, do we have like a Wednesday night or something?
so the 18th would be the next, so the 17th and the 24th, there's nothing on here.
So the 17th of
November.
Wednesday before Thanksgiving.
Yeah.
The 17th would be better.
Does the day before, the 17th, work with any of you?
So.
Which month are we in?
November.
Trying to recall.
I know the planning board had a special meeting.
That's what I'm trying to
Yeah.
We were just discussing among the three of us, December 16th. I think that works for all of us, if that works.
That's our regular meeting in December, so we'd skip November for you.
So we only have one thing in November, too bad, it's empty.
Yeah. If they can't meet, I mean, what else?
Oh, no, I'm okay with it, if they don't mind waiting the extra month.
December 16th
That
then?
work for our council?
December 16th would be fine.
It's our regular meeting, so.
Yep. You guys all good? Everybody good? The Bahamas and everything? No?
I'm back to
Australia?
Block Island.
Block Island? Okay, so then, would you like a motion for us to move it to that?
Okay, yesterday.
We need a motion to move it to that?
All right,
All right, so can I entertain a motion? that
Wouldn't
we,
it be a motion to continue to the 16th?
Yeah, so we're gonna continue this hearing, to the 16th to finish, testimony,
I'll make a motion, we continue the hearing until November 16th.
December 16th.
December 16th,
Wrong
sorry.
month. Second. We got seconds and thirds. Any discussion on that?
Just that it remains open.
Yes, oh yes, the hearing's still open. Okay, all in favor? Aye.
Make the motion.
Thank you,
adjourn.
gentlemen.
Yeah, thank you all.
Do it next month.
And have a good Thanksgiving and all those other holidays that may come in between.
We got the minutes already.
You don't have a Board of Appeals meeting.
We approved the minutes.
Yes, well, yes, we're gonna be
No, you
coming in as a Board of Appeals, we have a zoning board.
We approved the meeting for zoning board.
probably don't have you need to have a Board of Appeal meeting. That's,
Yeah, she, you gave us an opportunity. I know you did.
sure did.
I didn't have time to look through it.
Under Board of Appeals.
Zoning board. Board of Appeals.
Sorry. It's not, it's all here, it's just me.
I know, it's 10 o'clock
I
again.
got mine shuffled together, I started when I tried to go.
Oh, it's 10 officially by Verizon.
I put a transcript in for you. There's, it's a transcript from the remedy from last month.
Thank you.
All right, hang on.
Because that's not real.
No, that's I swear you did it.
No, I know you did it. I know it's here, I'm not down the other. Alright, so,
I make a motion, we approve the zoning board of review sitting as the Board of Appeals meeting minutes from July 15th, 2021.
thanks. You got a second? Any discussion?
Yes. Abstain from voting because I recused from that matter.
Yes, so Chip, you'll be voting on this, you sat on this one.
It was for July. We were here for July.
Yeah, you were present in July. Okay, so we have a motion second. All in favor? Aye. All right, Dan Rudy abstained as he was not here. Any other business?
Make a motion to adjourn.
Second. Any discussion? All in favor? Aye. Thank you.
Thank you.
Get some rest. Sorry. So Bruce next month? Yeah, that's not bad. That's not gonna happen. Keep that down.
Is that off yet?
I don't know.
I like that, huh?